rise. The justices of the Appellate Division, Supreme Court First Department. EDE, all persons having business with the Appellate Division. Draw near, your sentence shall be heard. Proceed.
Good afternoon and welcome to the Appellate Division. I'm about to call the calendar. When I call your case, please answer and then indicate to me the time that you're requesting for oral argument. I'm going to start first with People versus Massey.
Appellant requests 5 and 1.
Appellant requests 5 minutes.
5, 1, and 5. Thank you. Scioli versus Joseph. Yeah, do we have a respondent? No one did? Okay, so we only have the appellant here. Do you wish to argue?
Yes, but I need to advise the court the respondent's counsel sent me an email today saying that he is ill.
That he's ill? Would you like to submit then? I'll give you 3 minutes. Okay. Thank you. Thank you for informing me. Annette R. versus Dakeem D. Submitted. People versus Norman Anderson. Submitted. The snow kept people away. Okay. Rennock versus Rennock. Submitted. All right. Almonte versus Shaukat. Okay. The appellant, I'm going to give you 6 and 3 minutes for rebuttal. And for each of the respondents, you'll have 4 minutes. Mulrow versus New York Presbyterian.
For the defendant's appellants, 5 and 2, Your Honor. Appellant requests 8 minutes, Your Honor.
Appellant has 5 and 2, respondent has 5. Royland versus McGovern and Company. Now, we have a lot of parties on that. Let's start with the Marshals defendant. Right. Okay, thank you. Okay. And we have McGovern also here. You don't want rebuttal because you're an appellant. Okay. Okay, and okay, right. This is only complicated by the number of parties. So for Marshals, you get 6 and 2. For McGovern, you get 5. And the respondent, you get 6. Thank you. People versus Panlitz. Eight, 2, and 8. Wiener versus Anderson. All right, appellant, you get 4 and 2, and respondent, you get 4. People versus Bowman. 7, 2, and 7. Thank you. Stern versus Sullum. Appellant gets 5 and 2, and the respondent gets 5. Thank you. Trigon versus SDKD. We have an appeal and a cross appeal.
Appellant respondent, 6 and 3, Your Honor.
Good afternoon, Your Honor. Respondent appellant, also 6 and 3.
I'll give you 6 and 3 and 6 and 3, although that's a lot of time for this case, so, use it wisely. All right. Okay, but I'll give you what you asked for. Okay, thank you. Castello versus Fong, submitted. In re Renren, submitted. All right, the first case on the calendar, People versus Xavier Massey.
Good afternoon. My name is Elizabeth Vasily, and I represent appellant Mr. Xavier Massey. May it please the court. The seizure in this case hinged entirely on a bare-bones description contained in an anonymous tip that was entirely unverified, and there was absolutely zero information about the tip's source or basis of knowledge. There are two major issues here. The first is that the tip was so incredibly general, it could have encompassed countless people. The description was merely a Hispanic man in a blue jacket on a corner. This is much broader than any tip in any case cited in the DA's brief or other jurisprudence.
Did the nature of the tip or the information that the police officers have change when they got to the location that the tip directed them to? Was there additional information that the police officers had in terms of determining what the DeBoer level was?
The police officers would assert that there was a bulge in Mr. Massey's pocket. However, a bulge in the pocket, and the bulge did not otherwise resemble a gun. It wasn't large. There was no descriptors of it. And in the day of cell phones, Your Honor, everyone has a bulge somewhere on their person, and it really offered no additional probative value to escalate the encounter to a greater level of intrusion. And not only was the tip extraordinarily general, but we don't know who called, we don't know anything about it, and it wasn't even played in court. And that's rare, because in many anonymous tip cases, you have the call played in court, you have the radio played in court, and then the caller remains anonymous. But here, that didn't even happen. It was merely a police officer who testified that he received a tip and he went there. And the court erred by not considering whether the tip had truth to it, whether it had basis of knowledge. Was it eighth hearsay? Was it someone's friend of a friend of a friend telling them that this happened or that they saw this? And if we don't have these protections on anonymous tips, this goes contrary to the Court of Appeals' concern when it adopted Aguilar-Spinelli, which is to have veracity check and a basis of knowledge check on anonymous tips. We wouldn't want to rubber stamp every tip that comes through. I could call right now the police and say that there's a woman in a black jacket and she's white and she's on the corner of the courthouse, and surely I don't know anything. I'm standing here right now, but many people could get approached and stopped and get their constitutional rights violated based on a tip that has no information. Another thing is I could call the police every day on my neighbor who I don't like, and every single day the police on this anonymous tip could come and interrogate them or detain them, and that's why we need checks.
Counsel, can you address the waiver issue? He waived his right to appeal, and yet here you are. So can you address that issue, please?
First of all, the DA did not address this in their response, so they forfeit that argument. But as to the merits of it, it was a court-mandated appeal waiver. It was not requested by the prosecution, and because it was court-mandated, they should have, the court should have put on the record a reason for why he was qualifying a waiver on the record, and the court did not do that.
Isn't that a rule? I know that's a rule in the second department, but we've never adopted that here, have we? In fact, quite the contrary, we don't require that.
It still raises questions about court-mandated appeal waivers, Your Honor. Although it has not yet been adopted, it could, Your Honors could choose to do so today.
Well, actually, but we've never followed it. We don't throw out a waiver on that basis. We've never done that.
And
In this-
actually, counsel, my notes tells me that when the court made everyone aware of the waiver of the right to appeal, the defendant said he had already signed it. He had signed the waiver of appeal, the written waiver of appeal, before even the court mentioned it. So it doesn't sound like the court was imposing the waiver of appeal. It seemed like someone just forgot to mention it, and he was already done before the court mentioned it.
The court did initiate the waiver. I think the court was the one that said, does anyone have a waiver? Then Mr. Massey signed it, but it was on the court's terms where
I
this
understand,
waiver
no,
happened.
but the timeline, it's okay, fine, I got it.
Okay.
Right.
All right, you'll have some time on rebuttal. Thank you.
Good afternoon, Your Honors. John Hughes for the people.
So let me just ask you straight up, are you waiving your argument that the defendant waived his right to appeal?
So in this case, Your Honor, in our brief, we decided to focus on just the merits of the suppression issue. But I would note, as Your Honor has pointed out, that this court has not adopted the Second Department's rule in Sutton concerning appeal waivers.
So are you still pressing the appeal waiver or not?
Not at this time, no.
You're not pressing the
That's correct,
appeal
yes.
waiver?
Yes. Now, to turn to the DeBoer issue in this case, the officers in this case acted reasonably at every stage of the encounter.
Well, let me ask you a question, because I don't think there's much dispute about the facts. So they got an anonymous tip that there was a man with a gun at a certain corner. There was a very general description given of a Hispanic man and some of his clothing. Isn't it true that we have cases that say that in and of itself will not justify a level 2 intrusion, right?
I disagree, Your Honor. I think the case law is very clear that even a general description given by an anonymous informant talking about a man with a gun at a certain location provides founded suspicion for the police to approach and exercise their common law right to inquire. That's what happened here. This court has found that in Dawson and Gaines, and I think the Court of Appeals has said that too, both in Stewart and Moore.
Well, actually, in Gaines, I think that we decided the opposite, that would not be enough all by itself. So did you have more here? By the time they got to the corner that had been described in the anonymous tip, right? Somebody gave a tip, said somebody's standing at the corner with a gun, right? What else was in front of them at that time that may have enhanced the situation from what certainly was at least a level 1 to a level 2?
Well, so beyond the tip, which of course described the person with the gun's gender and that he was Hispanic and said he was wearing a blue jacket, so the officers arrived at the corner that the 911 call directed them to within seconds, so very, very quickly. Defendant was the only person on the corner who matched that description, which is very important. And I think, too, the police, even from when they were sitting in their police car, they noticed that he had also had a bulge in his jacket. And yes, there wasn't a specific testimony about what exactly the bulge looked like, but that certainly dovetailed with what the 911 caller had told them about that. And importantly, too, even
Meaning it was somewhat corroborative of the tip that the man was observed with a gun.
Yes, exactly, Your Honor. And even with all of that, the officers here acted with restraint. They didn't immediately arrest defendant, they didn't immediately frisk him, and they didn't even immediately stop him. Instead, they just walked up and asked to speak to him, which was absolutely justified under the law. And then, of course, in response, when defendant immediately began sprinting away, and during that flight is when he dropped this loaded revolver onto the street. At that point, when he decided to actively flee, the officers plainly had reasonable suspicion at that juncture to pursue him. If the court doesn't have any other questions, then I'll rest on my brief and ask that you affirm. Thank you very much.
Thank you. Rebuttal? You can proceed.
Um,
Go ahead.
He did not immediately sprint away. The testimony was that the police officers asked him if he wanted to talk to them. Mr. Massey said no, and then he ran away. But at that point, the record does not say that he sprinted. He was asked if he wanted to engage with the police. He decided that he wanted to exercise his right to not engage with the police, and he did so. And there's many reasons that people would flee from the police, especially in the anonymous tip context where maybe he thinks they've mistaken him for somebody else. And there's many reasons people would want
Well, he didn't know that they had an anonymous tip. He didn't know anything then about, they just said, can we talk to you?
That's true, Your Honor,
Right.
but
So-
you have
so
to
I
think
don't
something's
that
up
that-
at this point.
Well, in other words, in looking at his motivation, I don't think that he could, in his mind, think about the anonymous tip as part of the motivation. Certainly, part of the motivation could be, I'm exercising my right. I don't want to talk to you. I don't have to. Yeah.
There are no further questions.
Anything further? Okay.
Thank you.
Thank you. Thank you both. Okay, Scioli versus Joseph. You can proceed.
Good afternoon. My name is Delcia G. Marshall. I'm with Schaefer Partners, LLP, and we represent the appellant. This case involves a two-vehicle motor vehicle collision. It's a rear-end collision, and the lower court, based on a motion for summary judgment as to liability, granted liability to the plaintiff, Nicholas Scioli, the respondent here.
Can I ask a question? Your position really is that there's an issue of fact about whether the pedestrian darted out into traffic causing an emergency, correct?
Yes, and we believe that the dart out is the basis for our position of the non-negligent explanation.
Understood, but what I didn't see is any indication that there was a scintilla of proof that the pedestrian darted out. Your client doesn't say, I saw the pedestrian dart out. And in fact, the police report records that the pedestrian was crossing with a steady light in the pedestrian's favor. So what is the basis for saying that we have an issue of fact other than just speculation?
Your Honor, with all due respect, it's not speculation.
I'm respected.
Here.
I'm
What
respected.
happened here is
Go ahead.
we only have two conflicting.
Yeah, but your
affidavits.
client's conflict isn't based on personal knowledge. He doesn't say, I saw the pedestrian. He doesn't say it. I'm back and I looked specifically for it.
But however,
How does he say this?
the police report does indicate that there was a pedestrian crossing.
But that the pedestrian was crossing legally. That's what I looked at the police report too.
But in this case, the reason why we believe that the lower court's decision should be reversed, here we only have the two affidavits. We didn't get the opportunity to take depositions. This case was filed, summons and complaint filed, and shortly thereafter, the motion for summary judgment was filed. So
Right, I
most
saw
of the
that.
case law cited, there's either deposition testimony, trial testimony. There's more to base the judges or the court's decision on. Here, because the motion, in our view, was filed prematurely, we don't have more in the record.
Okay. Any questions, colleagues? Okay, thank you.
Okay, thank you, Your Honor.
Almonte versus Shukat. Okay.
I feel like I'm unpacking for a weekend trip.
You can begin.
Thank you. May it please the court, I'm Annette Hassapidis, appearing for the plaintiff in this case. Respectfully, the lower court erred in dismissing the action. If the court looks at the oral argument and the judge's reasoning in its determination, there were 3 errors. First, at page 62 of the record, the court concluded that an unspecified lump in the breast is a diagnosis. Now, the record here is undisputed that we had physicians on both sides saying whether or not that, in fact, is a diagnosis. Dr. Shawcott, at page 1426 of the record, and the plaintiff's expert both indicated that that is a clinical symptom, not a diagnosis. Drs. Mazarin and Melman said the opposite. So this was clearly a disputed issue of fact that the court resolved. Second, at page 65 of the oral argument transcript, the court speculated that P.A. Rogan had in fact told the plaintiff that she had to follow up for screening and in light of her family history. The plaintiff, at pages 8 in her deposition, testified that she was relieved when she left the ED because P.A. Rogan had told her she had a water cyst, it was mobile, she was sure, and that she received no discharge instructions. So when the court speculated that the plaintiff was fearful of mammograms and chemotherapy, and therefore when P.A. Rogan was speaking to her and recommending a mammogram, the plaintiff tuned it out. The court was engaging in fact-finding. And moreover, plaintiff never testified that she was fearful of mammograms. It was a conclusion that was not found in this record. The plaintiff was admittedly fearful of chemotherapy. Third, at page 66, the court actually flagged an issue for this court and said the appellate division, may address this. The court found that Dr. Brenner never opined that it was a departure to fail to develop a differential diagnosis. Nothing could be further from the truth. At pages 3246 of the record and paragraphs 38 to 39 of Dr. Brenner's affidavit, he specifically says that P.A. Rogan deviated from the standard of care by failing to develop a differential diagnosis. So the underpinnings of the court's reasoning are in error with all due respect. Next, the plaintiffs argued below and on appeal that the defendants failed to make out a prima facie case. They relied on and produced plaintiff's depositions. She testified at three different dates. And all of the defendants, below and on appeal, and their experts, have either disregarded the plaintiff's testimony or called it incredible as a matter of law. First of all, the reason they say that is because the plaintiff says, this is not what the PA told me. And at pages 820 to 823 of the record, the plaintiff acknowledged that she had signed the acknowledgement that she had received discharge instructions. But at her deposition, when she was shown the instructions, she said, I don't recognize that. The defendants are saying that that's incredible.
But she did recognize her signature.
She did indeed.
Right, and that consists of, I'm not even sure, but it seems to at least consist of 2 pages that were printed up. And that's where there's an indication, discharge instructions given, and it says breast cyst and fibrocystic breast changes, easy to read.
That's correct, Your Honor.
But we don't know, by looking at this, what exactly did or did not accompany this 2-page.
That's correct. My client acknowledged that she did receive some information about breast cysts, but nothing else. And really, plaintiff corroborated her recollection that she had not received the discharge instructions that the defendants have produced. Now, the defendants' record and their version of the discharge instructions is located between 1615 and 1631 of the record.
Counsel, there are scribe notes, right? Someone sat in there and wrote down exactly, there are medical records that support the defendant's contention. The scribe said, this is what she was told. Go get a mammogram. Important to get a mammogram. Go get a sonogram. There are medical records that confirm that, correct? Well, now, so you are saying to us, well, she disputes those medical records. Is that your position?
We made 2 arguments. First of all, no one said that the scribe recorded this contemporaneously. No one said that this wasn't dictated to a scribe after the fact. No one has established that a scribe, in fact, heard the consultation between the plaintiff and PA Rogan. And moreover, the plaintiff actually retained the instructions she was given, and she produced them in opposition to summary judgment. There are pages 3284 to 3295 of the record, and every field that could be populated, diagnosis, everything, says excluded, not available. Now, in reply, the defendants didn't produce a single witness to establish that this was not admissible, was not relevant, was not prepared by them, even on appeal. They didn't even address it. And the court mistakenly failed to address it as well, because if you, in this case, what better question of fact as to what plaintiff was instructed to do you need than two different sets of documents prepared by the defendants that purport to be discharge instructions? One, which is still deficient in our view, but the other that the plaintiff produced, which says absolutely nothing. And for that, on that basis, summary judgment should have been denied to the defendants. Now, even if we disregarded my client's copy of the discharge summary and we looked at what the defendants proffered, there were still questions of fact. Plaintiff had two theories of liability, right? The first was based upon the blank discharge instructions, so to speak, and the ones that defendants produced. I see my time is up.
Right. So I'm going to ask you to wrap up your argument.
Yes.
And you'll have some time on rebuttal.
Okay. With respect to the second theory of liability, there was conflicting expert opinion. Dr. Brenner opined that statements that say
This
breast
doesn't
cyst...
sound like a wrap-up, no offense, but, right, this sounds like you're
there were
going full-fledged into your new argument.
I apologize, Your Honor.
Right. You don't have to apologize, but you see, we have busy calendars.
Yes.
You know, we want to hear you.
Yes.
And I don't want to cut you off in the middle of a sentence, but wrap-up is wrap-up. You'll raise that on
Thank you.
rebuttal, okay?
I'm a bit enthusiastic. Thank you, Your Honor.
I'm not going to hold that against you. Go. Okay. You may proceed.
Thank you, Your Honor. May it please the Court, Dean Pillarella for defendants, respondents, P.A. Rogan, and Queens EMA. The single dispositive issue in this case is whether P.A. Rogan properly provided plaintiff with instructions to follow up at a breast clinic upon her discharge from the ER. Doctors Melman and Brenner were in agreement that breast cancer could not be treated in the emergency room setting, and that therefore referral to a breast clinic was the next logical step.
So the question is your client, if I recall, does not have an independent recollection of what transpired that day, right?
Yes, she based her
So
testimony.
it's basically her word against plaintiff's word. Plaintiff says she was absolutely relieved to hear that it was a water cyst because, you know, when you hear the word cancer, all the alarm bells goes off. So she's testifying that once I heard it was a water cyst, you know, I was just so thrilled. So that, you know, that kind of, there's two stories here. There's two versions here. So why isn't that a factual issue?
Okay, so with respect to plaintiff's testimony, with respect to the water cyst, number one, plaintiff admits in her affidavit that was submitted in opposition that she received the exit care information, which clearly instructed her breast cysts must be monitored closely because they could be dangerous. Because they can be cancerous. Also, as we argue in our brief, the testimony with respect to a water cyst is incredible as a matter of law because it's belied by almost everything, in the record. It's belied by plaintiff's acknowledgement of the follow-up instructions at page 3190 of the record.
Well, isn't it, let me just say, isn't it consistent, though, with the page that she signed, where it says discharge instructions given, and then right underneath that, it says breast cysts, 227, 216.
So it also...
Fibrocystic breast changes, easy to read.
And that, yes, Justice.
So doesn't that refer to the documents that she produced and said, here, this is what I got. I didn't get nothing else.
Well, she acknowledged her signature.
I know,
on
but
that.
her signature, there's nothing on this particular page that says, you know, this is suspicious or maybe suspicious for cancer. You need a mammography. There's nothing about that.
Okay, well, number one, it does say follow-up instructions, follow-up location, breast clinic, phone number, location.
It does, but what I'm
Yes.
saying, isn't this, you said there's no evidence that disputes it, and I'm saying this particular page, to me, seems a little ambiguous and equivocal, unlike the treatment care plan that is in her chart. In her chart, there's a very specific care plan that talks about follow-up with the mammography, follow up quickly, go to the breast care center, and we don't know really one way or the other whether that was the instruction that was given to her or not. It may have been, but I just have some questions about whether this is summary judgment kind of case.
Okay, Your Honor, if I could address that.
Sure.
Doctors
why I
Melman,
asked it.
Doctors Melman and Brenner were in agreement that the standard of care is to get Ms. Almonte, tell her that she needs to go to a breast clinic. She admitted that she received follow-up instructions. They told her the address and number of that breast clinic. Also, importantly, she doesn't...
No, but they didn't, but those instructions don't say, go get a mammogram. The discharge instructions don't say that. That's the problem. They
Okay.
say, here's the breast clinic, go to the breast clinic. But your expert opined that she had to go get, there would have been a good, the proper standard of care would have been to tell her to get a mammogram. But the only place that is in your hospital records, and you don't put up the scribe who created those records.
Could I please address that, Justice Gish?
Yes, you may.
Okay, plaintiff does not dispute receiving the exit care information. In her affidavit...
Again,
her
it doesn't say in the exit care information, go get a mammogram.
Your Honor, it states, and we quote verbatim in our brief, it says a breast, and this is at page 32.
It says go to the breast clinic. That's not the same as get a mammogram.
It says a breast x-ray exam, parentheses mammogram, and ultrasonography will be done to confirm the diagnosis. Fluids may be removed from the cyst with a needle, fine needle aspiration, to make sure the cyst is not cancerous. Same page.
That's in the chart.
That's in your
That's it.
chart.
No, plaintiff admitted receiving that. That's in her affidavit. Her affidavit is at page 3282 of the record. This is in her affidavit that she submitted in opposition. And this is attached to it.
Sir, you're referring to the CYST information, CYST information that she acknowledged she got. That's what you're referring to.
I'm referring to the exit care patient.
I know, but that involved description of the CYST. It doesn't, it's a different set of documents than the claimed instructions that you claim you gave her that reflected on 1619, 1620 of the record. Yes, she got that general information as a backdrop to allegedly being told by P.A. Rogan that don't worry about it, it's a cyst. And she was relieved, as you heard my colleague mention. She described that in her deposition, taken months before P.A. Rogan's deposition.
Okay.
Where P.A. Rogan and presumably your client had the ability to read what she said in her earlier testimony. So that's what's being asked of you. There's nothing expressly in the discharge instructions, my reference to 1619 of the record, where yes, that's her signature. But on that page that Justice Gish refers you to, there's nothing that says you should be going for a mammogram. It just gives the location of a breast clinic. And then when you turn the page, the next page where it says instructions, it's blank. It has boilerplate on top, but it's blank. Unlike the pamphlet or the manual or the other document that you're referring to that she acknowledged she got, which was from an educational point of view. Look, should you choose to go, this is what would happen. But that's what's missing here. That's what the issue is. She expressly denies getting precise instructions that are reflected in the treatment records.
Okay, so yes, it's true. There is nothing that specifically says you must go to receive a mammogram.
Okay, we're going to accept that because there's no but in that. That is the answer about whether, and I think we understand your arguments. Let's hear from the other defendants who are going to have similar arguments, so I want to give them time to argue. You're way over your time.
Thank you, Your Honor.
You're going to have to address the same issue.
Good afternoon. My name is Francesca Erickson, and I represent Dr. Nadia Shawkat, a board-certified emergency room physician in this case. So Dr. Shawkat is a little bit different than the other defendants in this case because the facts of the case as they pertain to her are clear and uncontroverted. So it's clear and undisputed that Dr. Shawkat never saw this patient when she was seen in the emergency room on the February 27th of 2016. It's undisputed that the PA that saw her did not call in Dr. Shawkat, and it's undisputed that her only involvement is co-signing the chart entry.
So isn't that the point that was raised by plaintiff's emergency room expert? That yes, we're not questioning the general policy of an attending administratively co-signing a chart that was recorded and presented by the PA, but we recognize that the PA is under the supervision of an attending doctor, at least as far as I know under New York law, and doesn't have the same kind of independent treatment protocol as, say, a nurse practitioner, by way of example. So the question here is, yes, all good, he signed off. The issue is whether your client was it a departure not to really analyze the chart and determine whether there are certain gaps there that may have required PA Rogan to be more proactive, so to speak, with the follow-up instruction. That's really the core, I mean, from that point of view. What is your position on that?
Yes, Your Honor. So on page 3198 of the record, which is PA Rogan's note, and PAs are permitted under New York state law to diagnose and treat a patient and write prescriptions, so they can act independently, and if they need assistance, that's what the attending is there for. But if you look at page 3198 of the record, and you look at PA Rogan's note, under assessment, it says, patient needs outpatient ultrasound and mammogram. It's pretty clear. For a breast complaint such as this, that is the correct course of action. So when Dr. Shawkat sees this, she is being treated appropriately. It says very specifically, ultrasound and mammogram.
But, okay, so once again, she signs off also on the discharge notes, right? And that's not said, it's not in the discharge note. It doesn't say in the discharge note, get a mammogram.
The discharge...
And isn't that what the expert is taking issue with your client is? The client should have called up the PA and said, the discharge note doesn't say get a mammogram, you better fix it. Isn't that what the plaintiff's expert complains about?
Right. So the note that Dr. Shawkat signs off on is very specific and does talk about an outpatient ultrasound and mammogram. She does not sign off on the discharge instruction. That's given by the PA.
And isn't that what the plaintiff is saying, that she should have looked at that and made sure that what was being told to the patient was not just, here's the address of the breast clinic, but go get a mammogram?
Well, if you look at page 3198 of the record and you read the assessment and plan, it's pretty
I
clear
agree,
and
that's the
specific.
hospital record, but the hospital record has nothing to do with what the plaintiff says she got. What everyone agrees the plaintiff got were some pieces of paper, not your hospital record.
This is all that my client had to look at when she signed off on the chart.
When she signed off on the chart, was there a representation in the chart that appropriate discharge instructions had been given?
Yes, it does say right on page 3198, patient will follow up as instructed, discussed all findings with patient and addressed any questions and concerns, to return to the ED for worsening symptoms. Patient demonstrates understanding of the findings and the importance of appropriate follow-up care.
Right.
It says...
but that doesn't tell us what she was told. I mean, that's part of the problem here. We don't know what she was told. But I'm actually looking at a different part of the discharge report on page 1627, where actually the plan is specifically says that the patient needs an ultrasound and a mammogram, right?
And that's exactly what.
And that's what the doctor would have looked at, along with, in that note, there's an indication that the patient was told about follow-up. So is that all she needs to do in terms of her signing off? Would that have been sufficient?
Yes, she would look at the PA's assessment and plan, which specifically state patient needs outpatient ultrasound and sonogram. Discussed importance of follow-up, given patient's symptoms and family history with patient. And on the prior page, 3197, it talks about that her mother had a benign breast biopsy and her maternal aunt passed away from breast cancer. So we know it was discussed with the patient. So when Dr. Shaw...
Well, we know what was represented in the chart about what was discussed with the patient.
Correct.
I think that's the problem.
But that's all my
I'm going to
client-
ask you to wrap up your argument,
Yes,
too.
but again, the chart is all my client had when she came in to co-sign the note. It was the next day. She was never called in. She never saw this patient. So based on the chart and what she read in the chart, that would be her only, she would say that the proper care and the proper recommendation was
Okay,
made.
thank you.
Thank
All
you,
right,
Your
let's
Honor.
hear from the last respondent here.
Good afternoon, Your Honors. I'm Barbara Goldberg. I represent Nurse Fabian Varas and New York Presbyterian Queens. I would like to point out that plaintiff is attempting to impose an inappropriate burden on the nurse whose sole involvement here was simply to hand the patient the discharge papers. Essentially, plaintiff would have the nurse second-guess P.A. Rogan and determine whether or not P.A. Rogan's discharge instructions were adequate or not.
Well, she doesn't remember.
She doesn't
your
remember.
client.
She's in the exact
She
same
doesn't
position.
know whether correct or not. She doesn't know what was passed over.
She can only go by what is in the chart, and in that sense, she is in the same position as P.A. Rogan and Dr. Shaukat, but she testified that her function as a nurse is to hand the patient the discharge instructions, ask if she understands them, ask if the patient has any questions, and remind the patient of the location of the follow-up. She had no involvement in formulating the discharge instructions, nor was she in a position to make a diagnosis, and in fact, no one is claiming that the nurse should have made the diagnosis. So despite Dr. Brenner's attempt to say that the nurse had an obligation to look at the instructions, realize they were inadequate, he doesn't even know whether the nurse had that expertise or not, his opinion, I submit, is not sufficient to raise an issue of fact as to whether the nurse departed from accepted practice. Again, the nurse is not making the diagnosis here. The nurse is not formulating the discharge instructions. And just one interesting point here, the plaintiff is focused on the fact that she was never told to get a mammogram, but there is a reference in the records of one of the subsequent treating providers after she went to Pennsylvania, after she moved to Pennsylvania. It's at page 2102 of the record. The subsequent treater noted that the plaintiff refused to get a mammogram, and that ties into the other argument that I've addressed in my brief, which admittedly was not reached by the Supreme Court, who found no issues of fact as to departures. But I submit that the plaintiff's entire theory of causation here is pure speculation. If the court looks at the delays attributable to the plaintiff...
Yeah, but it's pure speculation on your part as well, and you have the burden of proof on the issue of causation. I mean, the loss of chance is a doctrine that's pretty well recognized in medical malpractice cases all over the state. So I don't really understand the loss of chance argument here. I understand deviation because the standard of care is an issue of law, but I don't think it's your best argument. Let's put it that way.
Okay, I'll just say very quickly, I'm not even getting to the loss of chance. There are too many assumptions that have to be overcome before you would even get there, and the assumption is that even if the plaintiff had been given discharge instructions that said in 14-point time.
But you're confusing the burden of proof. It's your motion. So you're making the assumption that she wouldn't. I don't know. It's as speculative
Your
one way
Honor,
as the other, I suppose.
May I just answer?
Sure.
I'll just finish very quickly. We did address proximate causation. We submitted the affidavit of Dr. Schmidt, who said that the alleged delay made no difference. So we did address proximate causation. We met our burden.
Yeah,
in that respect.
but honestly, you didn't, because all you said was that she was going to get the same treatment. And there was an expert the other way. It doesn't matter. I mean, you know, and we kind of know in cancer treatment anyway, that of course you get this, or I shouldn't say that, frequently you get the same treatment regarding what stage the cancer is. But I think there's a sensibility that the sooner you catch cancer, the more effective the same treatment may be. And that's really what's at stake here. So the idea that just because she would get the same treatment, whether the cancer had metastasized to her brain or not, is somewhat irrelevant, at least to me.
But
right.
If I may just make one
sentence. Go ahead. And the only reason, and I want to reassure you all, we have your briefs and we have the record on appeal and we're giving it a lot of consideration. So I understand this is just a snippet and we have limited time here. And just because I limit your time doesn't mean we're not considering all your arguments.
And I appreciate that, Your Honor. But again, the bottom line as to the nurse is, it's very clear, and I think the court correctly determined at page 63 of the record, she did not breach any duty of care to the patient.
Okay.
Thank you.
All right, rebuttal.
Thank you, Your Honor.
All right, I'm gonna ask you, let's start with the doctor. The doctor is looking over the record, all right?
Yes.
And it may be, let's say there's an issue of fact, at least, we'll assume for a minute, about whether and what she was told when she was discharged. In the medical chart, however, which was reviewed by the doctor, it is pretty clear that, as recorded, that the treatment plan was that she would follow up with an ultrasound and a mammogram. She was given the name of a breast cancer clinic. It says in the chart that the PA told her, they gave her that information.
Yes.
What more was the doctor required to do? Was the doctor required to not accept that and to go and double check that? I don't understand.
Yes. Dr. Brenner opined, and I refer the court to pages 32, 47 to 48 of the record, that with respect to Dr. Shawcott, AMA guidelines require that she supervise the work of the PA. The problem with the PA's note is that it does not include a diagnosis. According to Dr. Brenner,
And that's the sole basis of your argument. So
yes,
in other words, if it had said rule out breast cancer rather than go to the breast cancer clinic and get a mammogram and an ultrasound given your family history of breast cancer, that's not a rule out differential diagnosis. According to you, that's
correct. The diagnosis here in the chart that Dr. Shawcott saw said unspecified lump in breast. Dr. Shawcott admitted that that is not a diagnosis in her deposition. It is a clinical symptom. And Dr. Brenner explained
which should have triggered saying,
correct.
Well, what does that mean?
What does that mean? What diagnosis did you give her? And one of the reasons Dr. Brenner explained you need a differential diagnosis and why it's a departure is that you discuss with the patient what she could have. You have a cyst, but you need to rule out cancer. And that the purpose of having a differential diagnosis that you impart to the patient is to let them know the imperative need of further scanning. When she's diagnosed with unspecified lump in breast and pages of paper that say breast cyst, but she's not given a diagnosis, it doesn't...
But the doctor doesn't, well, leave the diagnosis part out. The doctor has no information other than that she was given information about following up for imaging to rule out breast cancer.
According to that note, yes. Dr. Brenner's...
And that's what she's reviewing.
That's correct. And again, Dr. Brenner pointed out that the error here, the departure here, was failing to give a differential diagnosis. Let the patient know she possibly has breast cancer. Not, you need to go there. I mean, everyone needs to, it's almost like a matter of judicial notice that you need to...
And to your knowledge, in looking at the medical record, the chart,
Yes.
there's nothing there that would signal to the doctor that that is what the patient was told.
That's correct.
Okay,
That's
all right,
correct.
thank you.
With respect to...
No, I'm gonna
You're going to cut me off?
Yeah, sorry.
understand.
To
No,
all of
thank you, Your
I
Honor. You've been very
apologize.
indulgent.
I apologize to all of you, but honestly, we are going through your briefs very thoroughly. It's a serious case. Thank you. Okay, Mulrow versus New York Presbyterian. Okay, you can proceed.
Good afternoon, Your Honors. Gregory Casino for the defendants' appellants, Dr. Friedman, Dr. Cutler, New York Presbyterian Hospital. Your Honors, defendants' expert Dr. Jacobson, who is a board-certified otolaryngologist, head and neck surgeon, explained that the cancer to the right mandible, which was diagnosed in March 2016 at Mount Sinai, was also present when the plaintiff was treated by the defendants from February 2014 to February 2015, and was in fact what was causing her symptoms at the time. There's no allegation in this case that there was a failure to diagnose the cancer. It was a highly unique presentation of a squamous cell carcinoma. She went to multiple, she was treated at New York Presbyterian for a year, multiple biopsies there. She went to she transferred to care.
Meaning that they had always, talking about differential diagnosis, it was always kind of lurking in the background, and there had been testing for that while she was presenting with these infections in her mouth, right?
Exactly, Your Honors. So our doctor, Dr. Jacobson, explained that based upon the plaintiff's clinical course at New York, both at New York Presbyterian and at her subsequent treatment at Mount Sinai, that she always had an atypical form of cancer, including prior to her treatment at New York Presbyterian. And he also explained that because of this underlying cancer, the defendant's treatment of her presumed osteomyelitis could not have been the proximate cause of her bone loss, because any overlying bacterial infection couldn't have been treated and addressed until the underlying cancer was first addressed, and the only way to prevent the progression of the bone loss was to provide cancer treatment. Dr. Jacobson...
Sir, does your expert's causation opinion then rise or fall on whether it's established that the plaintiff did have that atypical form of cancer the entire duration of the treatment?
I would submit, yes. It was subsequently elected to treat. Again, it was never actually diagnosed at it. And what Dr. Jacobson did I guess, a retrospective analysis of the clinical course at one hospital, followed by the clinical course at another hospital. And I would also point out that when she was being treated at New York Presbyterian, the first biopsy that was taken in March of 2014 was reviewed by 3 different pathologists. The internal pathologist at New York Presbyterian didn't think there was anything there. They sent it out to Dr. Wenig at Beth Israel, and he said that he believes that there was something there. So then they got a third person at Johns Hopkins who looked at it and said, we don't think there's anything there. So, or that it's not cancer. So but then what happened is when she was then subsequently treated at Mount Sinai, they were having a very difficult time treating her at Mount Sinai. They were doing these resections, they were doing antibiotics, and that was not curing her condition.
Sir,
yes.
Plaintiff's expert, and correct me if I'm wrong, essentially claimed there was no cancer and that the departure was not properly treating her for the osteomyelitis, correct?
Correct, Your Honor.
But in fact, they were doing debridement or infected bone resection, they were treating her with IV antibiotics, seeing which one would work to address the infection, correct?
Exactly, Your Honor.
So notwithstanding attempting to try and determining whether there was some kind of atypical squamous cell carcinoma, the doctors were doing the very thing the plaintiff's expert said this.
Yes, Your Honor, yes. Again, that
There
goes...
was no departure.
Exactly, Your Honor. We believe that in this case, there's no evidence of the departure, but we also believe there's no evidence of proximate cause. And I would, just because of the fact that her condition was being driven by, her symptoms were being driven by this cancer, and again, there's no allegation of a failure to diagnose cancer. And I would just like to talk briefly about the plaintiff's expert before. The plaintiff's expert opines that there was no cancer here. The reason why the plaintiff's expert only reaches that opinion, because the plaintiff's expert, if you look at the statement of facts, the plaintiff's expert statement of facts ends in late 2014, beginning of 2015. This diagnosis happened subsequent to that. So we would submit that the plaintiff's expert, and Dr. Jacobson specifically looked at this evidence in coming to his conclusion regarding the issue of proximate cause. And I would submit that it's black letter law that on a motion for summary judgment, when a defendant's expert moves for summary judgment, points to medical records, draws a conclusion from that, particularly as it relates to the element of proximate cause, that when a plaintiff's expert just completely fails to acknowledge it, that does not meet the plaintiff's burden. If there's any further questions.
No, we'll hear from you on rebuttal.
May it please the court, my name is Matt Geyer. I represent the plaintiff's respondents. Your Honors, they're coming in asking you today to dismiss this case to grant summary judgment, and before summary judgment can be granted, it has to be established that they established their entitlement to summary judgment. They rely on Dr. Jacobson's affirmation. Dr. Jacobson's affirmation stands on one premise. That premise is that she had cancer from the very beginning. He creates that premise, he relies for that premise on the reread of the slides by the Mount Sinai pathologist, Dr. D'Amico.
Well, counsel, doesn't he also rely on the fact that she was treated for the cancer and got better? Right? She was treated for the cancer, right?
I don't know where anybody says she got better.
Well, her symptoms improved.
She was treated for cancer. Here's what happened. In 2016, they decided we're going to treat it as if it is cancer. The first time cancer was diagnosed on this record is 2018. That's the first diagnosis of cancer when they call it a recurrence. Okay? All right.
Well, part of it, though, the defendant's expert, was that she was treatment resistant. They were giving her antibiotics. She had infections, bacterial infections that were recurrent, and they were treating her with antibiotics, and she wasn't responding. It would respond. She'd say, "I'm feeling better," and then she's like, "No, I don't really feel better. It's getting worse." You know,
they were treating her with the same antibiotic, Augmentum. They started it in May of 2014, and they didn't do anything different until October of 2014 when they finally got an infectious disease consultant. That's what your departure is, giving the same antibiotic orally instead of intravenously, not getting an infectious disease consult, and also failing to properly do the surgery in the first place.
So let me just ask you this. The defendant puts up an expert who says there's no departure because this was cancer and that's what caused it. And your expert says this wasn't cancer, correct?
And there's an issue of fact.
Based on what? What is it that your client points to say that this wasn't cancer?
No. Dr. Jacobson, Dr. Jacobson,
whole premise is that this was not cancer. That's what your expert's opinion is based on. Am I wrong?
During the period of treatment, there was no, they removed the specimen in March of 2014.
Let's just go back. Let me just ask you, is your expert's basis of your expert's opinion on the fact that this wasn't cancer?
The expert's basis for his opinion that this wasn't cancer was the pathology results in 2014.
Right, so I'm just saying, That's the basis of your expert opinion,
That's
correct?
correct.
So, and the basis of that opinion is a test that was taken in 2014?
Yes, there were
And
two.
nothing in 2016, 2017, 2018?
That was not the
She
basis.
received gene therapy, she got surgery, she had maybe radiation.
If Your
All
Honor,
of that, he didn't take into account?
my expert did not discuss that other than in his affidavit to say that there was no basis for saying it's cancer all along, and he didn't address most of those subsequent care records. It's that simple, okay? But you don't have to get to my expert's affidavit if their expert's affidavit was insufficient. The one thing, and I think this was established and conceded, it all rises and falls on his assertion that it was cancer all along. To establish that, his basis for that is Dr. D'Amico, Mount Sinai, March 26 reread. She never says it was cancer from the beginning, not once. Well, here's what happened. Again, just bear with me for a moment, please. The first read is in March of 2014. It goes to the defendant hospital's pathologist, no cancer. Over to Beth Israel, Dr. Wenig. He sees, although you can barely read his report, he sees apparently a squamous cell carcinoma. Then they sent it down to Hopkins. Again, no evidence of malignancy. 2 out of 3 pathologists who read it say no malignancy. That's how they then treat her. Then in December of 2014, surgery, pathology at Cornell, no malignancy. Then at Mount Sinai, 2015, Dr. D'Amico, no malignancy. In 2016, again, no malignancy. And then somebody hands her Wenig's report from 14, not the other two, and she says, oh, there was a squamous cell. We got to reevaluate our review and see what that means. Okay, she does it, and she still doesn't come up with cancer. All she says is suspicious. So the only evidence of malignancy, she never said cancer from the beginning. The only evidence was Dr. Wenig's report, and there were 2 other opinions that were different. There's an issue of factor, and then they rely upon the hearsay from Dr. Friedman, where he says, I called Dr. D'Amico. This had to be after the lawsuit was filed, because the re-review was in 2016, and he says, I called Dr. D'Amico, and she told me it was cancer from the beginning. Never mind the fact that it's hearsay, that it's inadmissible, and that it's self-serving. Sorry, trouble through the mask.
All right. I'm going to...
I'm wrapping it up.
I know
And that
you
it's
are.
self-serving. But at best, it creates an issue of fact because it's inconsistent with Dr. D'Amico's report and never even diagnosed cancer. It doesn't exist in this record.
Okay, thank you. You can proceed with your rebuttal.
Thank you, Your Honor. I would just like to point out at the outset that most of what counsel just said right now is not contained in the expert report. That's the problem here, and that's why I ended my presentation by pointing out that black letter law is our expert says something, their expert has to respond in kind, and that stuff was not in the experts. That's legal arguments that he's making against what the evidence is right now, and I would submit that that would not be sufficient. And as to going back to this question of whether or not there was cancer throughout the period of time while the plaintiff was being treated at New York Presbyterian Hospital by the defendants, Dr. Jacobson's opinion was based on a whole host of things. It was based upon it was based upon Dr. D'Amico's 316 addendum report. But I would also point out that Dr. D'Amico's addendum report for March of 2016 she also based her report on Dr. Wenig's report.
Well, okay, was it at all based on the fact that she was resistant to treatment with antibiotics?
Yes, exactly, and that was something else that Dr. Jacobson based his opinion on. I mean, again, Dr. Jacobson is a board-certified otolaryngologist. He's looking at all the evidence here. He's looking at the clinical course at New York Presbyterian from February 14th to February 2015. and the Mount Sinai and what the treatment she undergoes. He's considering the difficulty the staff at both hospitals had in making the diagnosis, the realization at New York Presbyterian and Mount Sinai that the recurrent lesions and bone losses were not responding to aggressive surgical resection and antibiotics, and that when she did undergo cancer treatment, which here was radiation, and you don't radiate somebody unless you're sure that unless they have cancer. I mean, again, they use the term we're electing to treat this as a
I was
cancer.
going to say that, I mean, sure, it was a problem case.
It was extremely difficult. So I would just say that, but then when they gave her the radiation, she did, again, that was the biggest factor.
She had a more positive outcome.
Exactly, Your Honor.
Yeah.
So if there's any further questions.
Anything, colleagues? No, thank you.
Thank you.
Thank both of you. Royland versus McGovern.
Good afternoon, Your Honors. May it please the Court, Jason Lavery, Costa Brady, Megler, on behalf of Defendant Appellant Marshals Movers Service, Inc. Like any labor law case, the threshold issue in this case was the plaintiff engaged in work protected under labor law statute at the time of the accident. Was he engaged in construction or demolition work? Here, the plaintiff was finishing wood floors on the date of the accident. The court, in finding the plaintiff was covered under labor law, had a one-sentence analysis saying that his work installing and finishing floors is covered, citing to the case of Clavijo versus Atlas Turbs LLC. I believe this is the first mistake the court made in relying on that case. In the Clavijo case, the plaintiff was building an entire mezzanine floor, nailing plywood.
Well, let me stop you for a minute, because wasn't there a larger reconstruction or construction project being conducted at the church?
That is correct, Your Honor.
Right, and the floors were part of that larger reconstruction work, correct?
The floors were part of the larger
Right,
reconstruction.
so when we're trying to figure out if it's covered work, we don't look necessarily at the specific activity of a particular worker. In other words, if somebody comes in and they're a sweeper, but it's in a construction site, that's covered, right?
Judge, if that is my prevailing understanding of the law, the totality of circumstances would apply, particularly where there is a comprehensive service contract, such as the Pratt case that the plaintiff cited, and I believe misappropriately relied upon. Assuming what Your Honor says is correct, I don't think there was sufficient evidence supported to the court to find that with respect to when the installation of floors was done vis-a-vis the accident. The plaintiff had only been on the job 2 days and testified he was finishing wood floors, and that was what he was intending to do at the time of the accident. At minimum, Judge, I think there's an issue of fact on this issue that would require to be submitted to the jury whether construction work was being performed, whether he was covered under the labor law, and the appropriate inquiry that should have been used is not reliance on the Clavijo case, but whether or not the work was a substantial effect on the entire building structure, which I would submit finishing wood floors did not have a substantial effect on the entire wood structure, unlike the plaintiff in Clavijo, who built an entire mezzanine floor.
So the people who sweep up in construction sites not covered under your analysis?
I would argue that would be general maintenance as opposed to the construction.
Even if they're there specifically to clean up construction, it happens all the time.
I understand, Your Honor.
Yeah, all right. Okay, I understand your argument. I don't know if I agree with it, but I understand.
Well, I think, and again, it goes in the cross motion by the plaintiff, which was granted the burdens to prove no issues of fact, viewing the most favorable to the non-movement in that instance would be Marshall's. The 240 finding, I think, also was a mistake here. The plaintiff was injured while he's walking up a ramp with a passageway to the church where the accident occurred.
Right.
Not a scaffold, hoist, levee, puller.
But you could get into the building without going up those stairs, right?
That is correct, Your Honor. But the case law, the Jackson case in the First Department from 2018 squarely holds ramp into the building, not that it's a mere passageway, It's not a 240 case.
Yeah, but this ramp was specifically designed to assist the defendant that dealing with the organ repairs, and it was specifically designed where Marshall and Palagano, they were tag team here, and it was a ramp designed to address how to get something heavy into the church. It was specific for that purpose, and it wasn't just a passageway. It was designed in a sense. It was an elevated situation, which allowed them to do this. And the plaintiff, for whatever reason, chose because he thought it would be easier to use the ramp to get the buffer up rather than have to struggle up the stairs. Correct?
That is correct, Your Honor. But the cases I just cited to 3 to 4 foot incline, when it's a passageway such as this ramp, not 240, not a safety device. You're being used as a passageway versus a safety device. At minimum, there's also issues of fact where plaintiff was told by not one but 2 people at the site, do not use that ramp. And he used it anyway. So viewing the facts most favorably to...
Well, what was it? But there was no other way to get in. Isn't that true? I mean, I looked at the picture, and there was a claim, and the picture seemed to bear it out, that the 2 other access ways to the church, the other steps, were gated. You couldn't get through them. They were gated. They were closed.
Judge, he could have, respectfully, he could have asked someone. He could have listened to the foreman on the site.
Well, did the foreman testify? Not only that, he told him not to use the ramp, but he said, I will open the door for you, or you can get somebody to open the door, or use this entranceway, or go around the other way. There's a back entrance. There's none of that.
There's none of that, Judge. There is testimony. 2 people told him, don't use that ramp. He used it anyway.
And I'm not sure that's enough. That's what I'm asking you.
I think in opposition to a motion for summary judgment, again, plaintiff's burden, hearsay evidence could be introduced in opposition at this stage.
As long as it's corroborated, right?
Right. And lastly, Judge, the finding on 241-6 was based only, all the industrial code regulations were dismissed except for 23-1.22B3. That regulation only applies to wheelbarrows, buggies, hand trucks. Here, those weren't being used when the plaintiff was going up the ramp. He, after he was told not to go up the ramp, was bringing up a 200-pound sander. Okay, so on its face, that regulation should not apply. The court also mistakenly concluded that it gave...
I'm going to ask you to wrap up. It's my common refrain.
That's understood, Judge. You have a very heavy calendar.
You're going to, right, and you'll rely on your briefs, honestly.
Of course. Lastly, the one issue with regards to McGovern...
Lastly is not a tie-up. Come on.
I'll hold
you have rebuttal.
Thank you.
Come on.
I know how to be succinct. I represent McGovern. With respect to the 240 situation, I think the issue is the use of the ramp is not a functional equivalent of a scaffold. The pictures, while you're discussing this issue with the gate itself, the steps that were being utilized had room on the side. There's testimony to suggest there was room on the side, so that this ramp was only supposed to be utilized by the organ people, and that there was room on the side for other people to utilize the steps themselves. So with respect to 240, number one, it's not an enumerated device, meaning it's not the functional equivalent of a scaffold. And number two, because it's actual steps that are going into a building, and the ramp was literally on top of the steps, there's no height differential. Just merely because he may have been, the judge basically thought he was at a height differential. These are functional steps that you have to use to go into a church, and the ramp was put directly over them. They weren't, as again, related to a scaffold that was high over the ramp. He happened to have slid down the ramp, so he actually didn't even fall off the ramp.
But don't we have a body of case law that suggests, that doesn't suggest, holds that if a permanent staircase or even a permanent floor collapses, that still may be protected under 240? The point isn't whether there were devices or not. The point is whether the plaintiff was engaged in an elevation-related task that exposed him or her to an elevation-related hazard that then requires safety devices.
First, respectfully, he wasn't working at an elevated situation. His work was inside. He was bringing in a piece of equipment. This ramp was right over the steps. There's no authenticated differential and elevation, sorry. So when we're talking about heights, I understand the case law that you're talking about, but with respect to this case, the cases that should be followed are the ones that are a passageway that's just being utilized to bring one piece of equipment into a space. It's not within the construction site itself to be utilized as a scaffolding.
Go ahead.
I'm sorry, counsel, in the runner decision, when that huge wheel was going down a few steps, isn't that really analogous to what this
Okay,
situation?
I'm sorry,
I'm sorry, the runner case by the Court of Appeals. They were dealing with a differential far less than what was here. They were using this huge wheel and trying to get it down through a few steps, and it injured the plaintiff there. And that was deemed to be a differential case. And this case, we have a ramp where he was going up the ramp, and a section of the ramp, which wasn't braced, got loose, and he fell backwards with his equipment.
I believe runner could be differentiated with respect to the height. First of all, the first issue would be whether or not it was a enumerated device, and then secondary issue is the height elevation. With respect to runner, they were pulling an 800-pound thing and lowering it down.
Correct.
It pulled him down. Here, there's no
They were
real
rolling it.
evidence that the gravity was the cause of his accident. So I think runner, when you read runner in its totality, it is definitely you can differentiate the situation. Here, he's bringing something up, and then he's claiming that something broke off and he fell, but he literally fell off a side or straight down. Runner is they're pulling an 800-pound thing and rolling it down, and the force of the gravity pulled them because they had no hoist and no other enumerated no other enumerated device. The other two things very quickly, plaintiff has already conceded the 200 and the common law. With respect to McGovern, he didn't appeal it. McGovern, with respect to the 200 itself, the means and methods, the plaintiff was he owned Milford. He chose to go up the ramp as opposed to the side of the ramp or utilize some other way to get into the building. And with respect to a defect upon the property, it's clear that McGovern didn't know how Marshall and Paragallo were making the ramp, so that they had no notice of a defect with the ramp. And the third thing is, a subcontractor can be held in contribution for a case if they created the condition. The judge was absolutely right. There is clear evidence that Marshall and Paragallo created this ramp. They put it in so that at the very least there's questions about whether or not they caused the condition of the defective ramp, irrespective of what the court decides on the labor law issues. And with respect to common law, Paragallo, they were hired specifically to bring in the ramp, and Marshall created the ramp. Thank you.
Thank you. All right, respondent?
Good afternoon, Your Honors. I'm William Rose Valley for the Office of William Sorbonne, and we represent the Roylands. I think you have very adequately gone through all these points. Just a couple of quick items. First of all, my client had a contract to install and finish wood floors. It's in the record. It was far more than just cosmetically finishing floors. He had to put them down, properly set them up, finish them. It was part of an overall contract. He was there more than 2 days. I don't know where they got that point. The ramp here is not a passageway. You've adequately discussed that. It is a device that was put down by marshals for the purpose of bringing heavy equipment materials.
No, it would be, I mean, the passageway is the stairs.
Correct.
Right,
And
and
they
they put
blocked
the
it.
ramp on for a whole totally different purpose.
Correct. It's a tool and a device that was blocking the passageway. You're quite right, Your Honor. And that is exactly the point.
So, counsel, can you just address the notion that there wasn't he didn't really fall, there wasn't a big
Yes,
height
that's, I was going to get to that on the points. He did not fall from the ramp to the step. He was at the top of the stairwell on the ramp. The top of the ramp let loose because it wasn't properly braced, and he slid on the ramp as the ramp itself slid all the way down the staircase to the bottom, which is about 7 or 8 feet elevation distance, and he injured his knee on a concrete and steel gate at the bottom of the stairs. So this is an effect of gravity. It's an elevated height. It's not like he even just slipped on a wet ramp. The whole ramp let go. He didn't roll. He didn't roll. It was like surfing. He described it as surfing down the stairs on the ramp.
Instead of going 3 or 4 inches from the top of the ramp to that step.
Yes, exactly.
There's where the height difference.
Exactly, and that is the height differential.
So was there on the stairs clearance for him to walk up and not use the ramp?
There were, if you look at the pictures in the record, you'll see
Right.
there is some little bit of room on either side, but he couldn't, if you particularly look down at the grate, there was very little room, and he couldn't walk on either side with his equipment and not be on the ramp. And then what they're expecting him to do is to go through that gate and then stating that there's enough room on either side after that to get off the ramp with his equipment and now walk up the stairs. First of all, I dispute whether or not there was enough room on either side of the ramp to do that, and I think the record shows that that's an issue. But the bottom line is it's not a common sense item. You know, I mean, if you're starting to pull something up a ramp, then why would you, in the middle of that incline, get off of the incline and get on the stairs? It just doesn't make sense to do that.
Was he ever given it, or is there anything in the record that he was given instructions of an alternate way to get into the church?
Bruce Tarr, who's the principal of Marshall's, testified that only his people were supposed to use that entrance, and everybody else was supposed to use the side entrance. Marshall's testified that they were told on a day-by-day basis of, not Marshall's, I'm sorry, McGovern's employee testified on a day-by-day basis. The pastor said where they would go in and how. Royland testified that his primary entrance was those 3 gates that you see in the pictures in the record, and that on the day he arrived there, and at the time he arrived, everything else was locked. He had no other way to go in. So he had not been directly instructed to use another entrance. The only one who says that is Mr. Tarr. And there's no evidence other than Mr. Tarr's statement to that effect. Absolutely no evidence.
That Mr. Tarr told him to use another
No,
entrance.
Mr. Tarr says, I'm sorry, I apologize.
Yeah, right, go ahead.
Mr. Tarr said that the workers were told by someone from McGovern to go other ways into the office, into the building. Royland testified that his work was upstairs in the higher edifice of the church, that edifice of the church, and had he gone in a side entrance, which they spoke about, he would have ended up in the basement where he was not working and he was not supposed to be. But yet Mr. Tarr said everybody else was supposed to use the other entrance.
Okay.
Okay.
Understand.
I didn't get to McGovern, but I think you have adequately addressed all those issues.
Any further questions?
Yeah, if you have any questions. Thank you.
No, thank you. Okay, rebuttal.
Thank you, Judge. It was the McGovern foreman, Keynes, for the entire site that said no one but Marshall and Pergello employees use that ramp. And with respect to the finding that McGovern was free of fault, that was one of the things, one of the issues that Marshall has appealed, and we submit there is evidence viewing in the light most favorable of Marshall's that there is fault on them because, as Your Honor alluded, McGovern instructed Marshall's precisely to where to put the ramp on the date of the accident, which, as to Your Honor alluded, made it more difficult for the plaintiff to get up there.
But you concede it's a means and methods case.
Yes, Your Honor.
So your claim is that by telling the contractor where to put the ramp, that constituted supervision?
No,
So, I mean, how does McGovern come in? I'm sorry.
McGovern, see, there's still claims of contribution and impacts indemnification.
No, I understand why you want them in. I'm just wondering legally how they come in. We got a means and methods case, right? So you need to show that McGovern had some kind of supervision over what was going on here.
Well,
they had the right to direct the work. Did they?
I think, well, as a general, they were responsible for site safety, but I think it was also a defective condition in terms of the ramp itself.
So you don't agree that it's a means and methods? You think it's a defective
I
condition?
think it would be more of a defective condition, yes.
Okay.
And just back to the industrial code violation, the court and the plaintiff's expert both mistakenly assumed there was some evidence of this failing under weight pressure as a violation of the code. There's nothing in the record in that regard. And lastly, the experts, the court shouldn't have relied upon the plaintiff's expert's affidavit as it was conclusory and speculative in many regards, most particularly in criticizing the subject ramp. It relied on 2020 guidelines from the internet. This accident was 2010. Obviously, the ramp was well before that. The expert never visited the site, conducted no site measurements, so forth and so on. The additional reasons are all in my paper. Thank you for your time today.
Thank you. Thank you all. People versus Panlets. You can proceed.
Good afternoon. May it please the court. Stephen Chu on behalf of Carrie Pantlets. The combination of three factors in this case, all of them preserved, requires a Batson reversal. First, the prosecutor's multiple explanations were on its face suspicious, and the prosecutor made no attempt to connect them to the facts of this case. Second, similarly situated white jurors were not struck, particularly on this first panel. And although defense counsel pointed this out, this disparity is never explained by the prosecutor. And third, the trial judge held that the strike of Mr. Perez was pretextual. In other words, the court found that the prosecutor was not credible. Given this finding, the other explanations do not deserve the benefit of the doubt. And I'll start with Nicholas Vail. The proffered reasons here were that he was a self-employed jewelry designer and that he wore a trench coat. As the court said last year in People v. Murray, employment reasons can be discriminatory if they're not connected to the specific facts of the case. Neither the trial neither the DA nor the respondent really gave an explanation as to why being a jewelry designer mattered here. And I think this vagueness is part of the concern in this case because we don't know what the explanation is and because it's tied to long-standing prejudice and discrimination against Asian Americans in this country. I think a lot of caricatures and racism against Asian males are based on describing them as effeminate or emasculated. And without any further explanation here, we don't know what's going on. But furthermore, for the first time on appeal, the respondent has now said that maybe the combination of jewelry designing and wearing a trench coat means that there's some question as to their respect for authority. And I think that's one of the reasons that we can't rely on the vagueness in this case, because that kind of speculation is not what the prosecutor said below, but it also is trafficking in another stereotype, which is that we look at Asians as potentially disloyal and disrespectful for perfectly normal reasons. And that leads me back to the disparate treatment, that the defense counsel here clearly said there are two other white jurors here who also engage in creative arts. You have Ms. Zappacosta, who is a fine arts consultant and told the court that she engages in social commentary work. You have Mr. Redmond, whose wife engages in costume design. Neither of these white jurors were struck. And this disparity was told to the judge, was told to the prosecutor, and no explanation was given. I'll just talk about Joseph Perez briefly. This is the juror who the judge did find was improperly struck. But the pattern is similar. The prosecutor here explained that there was an educational background that he wanted for a juror and that Mr. Perez did not satisfy. The record doesn't actually say that.
But so why are you arguing about that? The judge agreed with you and put the juror back on. So that can't affect one way or the other your other argument, which is about the disparate treatment that certain jurors were struck because of their Asian backgrounds or their seemingly Asian backgrounds. We don't specifically know.
It does matter because of what the Supreme Court has said both in Flowers versus Mississippi and Snyder versus Louisiana, which is that if there is a strike that is not okay, that is a relevant circumstance for the trial judge, for this court, to review in determining whether the other strikes are reasonable.
But the court knew that at the time when they was trying to ascertain, and they still have to make an individual determination on each of the claims where you say it's discriminatory, they say no, and then you say it's a pretext, They have to give a non-pretextual reason. So I don't understand why you don't think the judge was involved in the appropriate analytic when the fact that he did already strike he agreed with you, it's sort of indicative of that he's looking at these individually and making appropriate independent assessments of them.
There are two reasons why we should not defer to the judge in this case. And the first one is actually structural, that there's no discussion of the prosecutor's employment rationale, which was central to this. This was not just an appearance rationale. It was that the prosecutor started and ended with, he's a jewelry designer. And the judge does not reference this in its decision. There's no discussion of the disparate treatment. And for these structural reasons, the judge doesn't deserve deference here, but also because of the substantive nature of the vague explanations here. What we have here is the judge kind of giving a wink and a nod to this explanation about appearance or trench coat or jacket, and we still don't know what the basis for that is.
Why is that connected to Asian Americans as opposed to any person? The U.S. Supreme Court says it has to show a connection. So, for example, he was wearing a yarmulke, maybe I could see, but I don't understand how that's connected to this particular group.
And I think part of the connection here is that what I just said earlier is that this country's history is to describe Asian men as effeminate,
I mean, that could be said for any number of groups of people. So it's not exclusive to one group of people. But the Supreme Court has said that you have to really make that second connection. So I'd like you, so if your argument is we always call Asian Americans effeminate, and we don't call any other group effeminate, then I have a hard time with that.
Your Honor, it's the second part of that, which is on step 3.
I got a question. Did you raise any of this with the trial judge as you were going? These arguments are, I'm listening to your arguments. Were these all brought to the judge's attention, the trial judge's attention?
So what was preserved for the judge very clearly was that there's disparate...
Did you make these arguments that you're making now to us before the trial judge?
The trial
simple
judge...
question, is it yes or no? All these arguments you're raising before me now, before us right now.
Yes.
All raised before the trial judge.
The answer is yes. The argument that defense counsel told the trial judge was that this is not a sufficient explanation, it is vague, and there's disparate treatment that these white jurors were not struck. All these were specifically made to the trial judge.
What about the argument about Asian American men are regarded as effeminate?
That statement was not made to the judge, but again, the vagueness here and the lack of specificity as to why the reason is connected.
But who was supposed to raise it? I mean, was the judge, when they said, gee, he's a jewelry designer, and apparently it was obvious he was a flamboyant dresser, you know, the judge is supposed to say, well, you know, are you insinuating that he's effeminate? I don't even know if he was looked effeminate or not. Can't even say in this record.
Exactly, we don't know. And as this court said,
but don't you have to give us a record? I mean, doesn't the court below have to have a record?
This is what happened. This is why this case needs to be reversed, because in Murray, what you said in Murray specifically was that when an employment justification is raised, it is beholden on the prosecutor to tie that to the facts of the case. And in this case, when defense counsel raises these complaints, this disparate treatment, this vagueness, the judge can't just cut off the conversation then. We have to know why the prosecutor is tying that in. Otherwise, we're just left with speculation.
All right. I have to admit, there's something analytically that's missing from me in your argument, and I guess it really goes back to what just Carpula asked you, which is the connection up in terms of the argument. All we know is that he was a jewelry designer, and apparently it appeared that he was a flamboyant dresser. There was no indication about any question, and no way for the court to address the argument you're making before us that Asian American men are considered effeminate. And quite frankly, you know, maybe the prosecution would have disputed that.
I'll reserve most of my rebuttal. Just to finish up, I think the vagueness and everything about the non-specific answer is exactly what this court has said in People v. Carlisle. This is not enough. We need to know that the reasons here were the honest reasons. We need to know that the reasons here were valid and sound in connection to the facts of the case. That didn't happen, and for those reasons, there should be a reversal.
Thank you.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors. This was ultimately a factual determination for Justice Hong, the trial judge, and that determination is entitled to great deference on appeal in this court. And here, Justice Hong did not see discrimination toward the two Asian American jurors at issue. That determination is entitled to great weight. It's also supported by the record to the extent the record exists. As I noted in my brief, the prima facie showing in this case was rather weak. It was based on only two jurors who were struck in the first round of jury selection. And this court's entitled to take the weakness of that prima facie showing into account when evaluating the overall record for evidence of discrimination.
Counsel, let me just ask you, the defendant's counsel said that all of the issues raised are preserved. Do you agree with that assessment?
Not in the least, Your Honor. The issues were hardly preserved at all. Counsel obviously below brought the Batson challenge, but when the prosecutor provided his explanations for challenging the two jurors at issue, Nicholas Liu and August Tan, the defense hardly raised any of the arguments that they raise now.
And what about the argument about prosecutorial misconduct? Do you think that that was fully preserved?
Not fully preserved. There were maybe snippets of that argument that were preserved, but for the most part, those claims were not preserved. For example, the claim with respect to the prosecutor's opening statement reference to the grand jury proceeding, his argument was not fully preserved. He did not move for a mistrial. Based on that, he contemplated moving for a mistrial and ultimately received an instruction regarding it in the judge's final instructions. With respect to the other aspects of supposed prosecutorial misconduct, I can't remember each of the specific instances that he's now claiming, but I think I went through in my brief exactly what his arguments were at the time with respect to all of those. And he, for example, with respect to his claim now that it was improper to refer to the victim in this case, the complainant, as the victim, there was no mention of that whatsoever. Never complained about that at all. There were certain aspects of the prosecutor's summation that the defense did object to, but didn't quite articulate the objections in the same way that he now complains about them on appeal. So, no, the arguments with respect to Batson and with respect to prosecutorial misconduct are not very well preserved by the defense. And I would mention, to come back to the Batson issue, that ultimately it's the defendant's burden to show that the prosecutor's explanations, which were on the face race neutral, that they were pretextual. That was the defendant's burden to show. And with respect to Nicholas Liu, the only argument that the defense made after the prosecutor explained that it was Liu's employment and his overall...
It was an overall appearance that the prosecutor didn't feel that he wanted to exercise a preempt with respect to that. That was it. And then from my reading of the record here, defense counsel didn't bring up all these arguments that are being raised now in front of us now about whether or not his orientation, sexual orientation, or and all the other stuff that's coming out. Unless I read a totally different record, I didn't see that.
Yeah, no, you're correct, Your Honor.
Because as my colleague says, Justice Gish said, you raised that below, the people are going to challenge that.
Right, exactly. The people never had a chance to respond to any of the arguments that the defense is making now. And the only argument that the defense raised below with respect to Nicholas Liu after the prosecutor gave his explanation was to quibble about exactly what the garment
Was it a trench
was
coat or
that
was it
the
not a
juror
trench
was wearing.
coat? Right.
And the judge, this is obviously in a case where a challenge is based on the juror's appearance. That's one that's particularly difficult for this court to second guess on appeal. But clearly there was something that struck Justice Hong as well about the juror's appearance, and that's why the judge granted or denied the Batson claim with respect to Nicholas Liu. With respect to August Tan, the appellate argument the defense makes with respect to disparate treatment, it relies on two jurors who were questioned in a subsequent round. And below, the defense never asked after that subsequent round of jury selection for the judge to revisit the Batson claim in light of those two other jurors. So, that just illustrates how poorly preserved the defense appellate arguments are with respect to the Batson claim. And overall, it leaves, I think, this court in a posture where the deference that is owed to the trial judge's determination has to carry the day. And that Justice Hong, who I would just mention, himself Asian American, and presumably would have been, vigilant about any discrimination towards Asian American jurors, that he found these explanations to be race neutral and non-pretextual, is entitled to great deference on appeal, and as it would be regardless of the judge's own background. So for all those reasons, I ask the court to affirm. Thank you very much.
Thank you. Rebuttal.
I'll just start by saying there's nothing in the case law that allows my adversary here to cite to the judge's race as an additional factor to consider here. But setting that aside,
I wouldn't worry about us considering that as part of the appeal.
I understood we all understand that, but I think.
Speaking personally,
Yes,
don't worry about it.
correct, and I think that's part of the argument here, and I just want to focus specifically.
My focus is that, my understanding of what transpired downtown was when the challenge was made and the explanation was given with respect to Mr. Liu, was exactly, when the prosecutor gave their explanation and then the defense counsel makes the argument of whether or not he was a trench coat or something else and everything, but not specifically raising all these arguments that you're raising on appeal now, which are very substantive arguments that the trial judge, you got to give them an opportunity. You got to raise in front of them so they can address it, because as Justice Gist said, invariably or indisputably, if you raise those arguments, the people are going to come back and challenge that. If they don't have that, that's it.
Yeah, so to answer you and Judge Scarpula specifically, on page 125, the objection raised was not just he was wearing a black jacket, it was also because he designs jewelry, that should not disqualify him. Ms. Zabacosta works with fine arts. Mr. Redmond works, his wife is a costume designer. I don't know that being in the arts or designing jewelry should eliminate somebody. And so what does the judge do? The judge doesn't discuss these actual legitimate arguments that are raised as to why this is pretextual, doesn't ask the prosecution to explain it, just decides on appearance. And under the case law, that's not enough, because if there is a reason...
No, but it's pretextual as to what group? Only Asian Americans? Are you saying that only if you're Asian American and someone says you're a jewelry designer, that's pretextual, but if you're African American or Caucasian or any other group, it's not?
If I might answer?
You might.
Yes, exactly, because that's what the prosecutor did in this case. He only struck the Asian person who was a jewelry designer. And if that is the reason, if we are concerned about being involved in fine arts, then he would have struck the white jurors, but he didn't. And it was incumbent upon the prosecutor then to present a reason why this identifying factor was so important that it only related to Mr. Liu and not to Ms. Zabacosta or Mr. Redmond. For these reasons, again, I request your reversal.
Thank you. Thank you both. Weiner versus Anderson. You can proceed.
May it please the court, I'm Stephen Leggum. I represent the defendant appellant. There's no question here that Hilton Weiner did not timely, but never sought a trial de novo. So what the plaintiff's trying to do now is get this court to instate a new rule. And I don't want to misquote, I'm reading right out of the record, the plaintiff's position: there is no difference between an attorney and his eponymous law firm.
Can we get to a more fundamental issue? Go ahead. Go ahead.
I'm struggling with the main issue, sir. Did you properly move to vacate the default judgment below? Yes or no?
Your Honor, there was no motion made to vacate the default. However, there was judgment entered. We filed a notice of appeal from the judgment. At worst case scenario is that the order of the default may not be reviewed. But all of the prior orders, once judgment is entered, all of the prior orders are subject to review. And my position...
You articulated that in your notice of appeal. So we're not dealing with the default. Your default stands. You can't be reviewed here, right?
I don't believe in this case there is a default, but assuming...
No, there clearly was a default. It may have been incorrectly entered, but it was a default. You know, that happens in a big court system. That's why you're allowed to make a motion to vacate the default. Plainly not done here today. So I guess one of the things, and I share the concern that I think that Judge Shulman is trying to address, is we may not have jurisdiction here.
Your Honor, there are multiple earlier orders, which now I can't review on a direct appeal because once judgment is entered, you can only appeal from the judgment.
Well, you would have been too late for that anyway, for the earlier orders. You didn't file notices of appeal on them. So, you know, if you vacate the judgment and then a new judgment is entered, not on default, well, then I suppose it brings up for review all of that stuff that otherwise is reviewable. You know, I think it's kind of a misnomer to say it brings up everything. It brings up some stuff.
However,
Sure.
Our position here is also there is no cause of action that's been stated because, and that's reviewable for the first time on appeal. Clearly,
I don't know what appellate law you're relying on, sir, but okay, I'll let you finish your argument. Go ahead. Tell me why there's no cause of action.
Clearly,
Tell us.
Clearly, there is no standing on the part of the entity. The entity is separate and apart from the individual. The entity never had a relationship with the defendant. The entity never received an assignment of the claim. The entity never participated in the arbitration proceeding. So what we have here now are two separate judgments against Lowell Anderson. We have both of which are based upon an invoice which Mr. Weiner assigned to another entity to asset-based funding. And now Mr. Anderson faces two judgments against him, not one. Mr. Weiner had the opportunity when we moved to confirm the arbitration award to oppose it. He did not oppose it. Based upon this, there was never any standing on the part of the LLC to proceed. The LLC never had undisputed any relationship with the defendant. Matter of fact, we don't even know that the LLC was a law firm. The Office of Court Administration.
Sir, did you ever raise the issue of standing in your answer or in your pre-answer motion to dismiss?
Yes, Your Honor. It was raised. We did raise that issue. That is preserved.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court, Paul Vink for the respondent.
So at least you have to acknowledge this wasn't the most crisply litigated case in the world.
I would certainly acknowledge that. If I were counsel for the plaintiff below, I would have done many things different.
There's a lot of things that are really kind of difficult in here, including the fact that there's a confirmed arbitration, which seems to be at odds with the default that was entered here, correct?
There is a confirmed arbitration award, but I think that Judge Bannon had both of these before her at the same time. And I think it's important to note that while appellant never considered them to be related proceedings, didn't file them as a related proceeding, didn't counterclaim in this proceeding for confirmation of the award, waited until the eve of his deposition in order to move to confirm the award, didn't have it automatically assigned to Judge Bannon, who got it anyway, really was using that proceeding as a backdoor to avoid his deposition. And I think it's clear that avoiding the deposition is the entirety of the defendant's, is the sole motivation here for everything that the defendant did. There are 6 orders for his deposition, and he never appeared for them, even under threat of his answer.
And accommodations were made for him. He said, I'm an old man, I'm in Iowa. And they said, okay, do it virtually, okay,
Yes.
we'll adjourn it, okay.
And ultimately he said, you pick the place, you pick the time, you pick the court reporter, we'll do it remotely, and we'll show up. And then it still never happened. And that was after the threat of striking the answer if that didn't happen. And then it didn't happen. But with respect to the trial de novo and the arbitration award, while they would seem to be conflicting, I don't think they are. For one thing, the confirmation of the award involved different parties, the LLC and Mr. Weiner himself.
Well, isn't that his point, though, that the plaintiff here has no standing because the arbitration and the relationship concern different parties, as it were?
Perhaps, but to the judge's question in the first place, standing was not raised as a defense in the answer. They did raise it on a summary judgment motion, and the court entertained the argument. The extent of the standing argument was 2 paragraphs that said exactly what counsel said. We didn't contract with the LLC, we contracted with Weiner. That was the extent of it. No case law.
Hard to say more than that. You don't have standing, it's hard to elaborate on something that doesn't exist.
Well, that's interesting, but you need more than just to say that when you've got a pleading in front of you that says, here's the invoice, here's the sequence of events, I'm the owner of the LLC, we sent the LLC sent the invoice, it was assigned to a factor. All of this was before the court, that the invoice was assigned to a factor, it came back to us when it didn't get paid, and that was the chain of events which created the standing. So they may not have contracted with the LLC, which didn't exist when the original retainer agreement was entered into. But that doesn't mean that they're not obligated to pay those claims to the LLC when they have been assigned by another entity, Weiner in the first place, assigning to the factor then reassigning back down. Now, yes, it's complicated, and all of this could have been addressed had parties appeared for their discovery and fulfilled their discovery obligations.
Counsel, is there anything preventing the movant from just moving to vacate the default below?
He's well past his time to do that.
Okay, because of the appeal.
Notice of entry was, yes, notice of entry was served.
Is it, so 50-15, he can't move under 50-15?
Correct. He's well beyond his 1-year time limit to do that. And that was his obligation, was to move to vacate the default on the judgment, so that he could then, if that was denied, appear before this court.
Okay.
Thank you.
Thank you. All right, 1-minute rebuttal, sir.
I would, with the court's permission, just like to address the one issue of the failure to participate in the deposition. We took numerous steps to try to participate in the deposition. When it was ordered by Justice Bannon, I contacted Mr. Weiner multiple times. He then sets a deposition for another state. We tell him that's not reasonable. He then says he set it up virtually. I never get a notification of this. I tell him specifically, he says his response is, and this is all in the record, his response is, go get it from the reporting company. I set it up with the reporting company. We contact the reporting company. They said, Mr. Weiner told us you're going to be here personally. I said, what time do you want the witness there.
Is any of this in the record?
This is all in the record, Your Honor. The correspondence with Mr. Weiner is in the record, and there's an affirmation about it. It's all in the record. I then said to Mr. Weiner, it's obvious.
You have to finish up.
One sentence, Your Honor. It's obvious that we can't do this today. Let's do it tomorrow. I'll give you dates next week. We tried. He was the one that thwarted it, and it's not my obligation to fix a date and time. Thank you, Your Honors.
Okay, thank you both. People versus Bowman. You can proceed.
Allison Kale on behalf of defendant appellant Robert Bowman. Mr. Bowman's trial was unfair from the very beginning of jury selection to the summations all the way to his sentencing. To start with, the court improperly instructed the prospective jurors that Mr. Bowman's sentence could, quote, run the gamut from anything in a criminal case from time served to probation to treatment to prison, end quote, in response to a juror's concerns with sending someone to prison. Mr. Bowman faced a mandatory minimum sentence of 16
Counsel,
years.
did you preserve that issue?
That issue is not preserved, but it should be reached in the interest of justice because under this court's case law, it's a very clearly reversible error and it impacted the jury. The jury could minimize the case here, not take it seriously, and accept that think that there might be leniency at the end of this when there absolutely was not any. And in this court's case law in Sherman and Santini, the errors here was more egregious. In those cases, defense counsel put this at issue. Defense counsel said something about the sentence, and the court issued still an improper instruction to try and correct that. Here, this was of the court's own making. The court's legally only supposed to say something about not speculating about sentence, and the court went far beyond that here. 3 of the 4 options that the court mentioned are non-incarceratory sentences that were not eligible to Mr. Bowman. Again, this is a life imprisonment case, and it warrants the interest of justice jurisdiction. And if not, it also was ineffective assistance of counsel for the lawyer to not object. And just to understand the impropriety of what the court did here, the court earlier in jury selection had a juror who wanted to sentence someone to a long term in prison, and the court's response there was, you can't speculate about sentence, and that was it. When we get to the opposite situation here, you have the court expounding on this, giving time served, probation, and treatment as potential options. And the error
Maybe we could spend a little time on the CPL 27020
yes.
issue. That seems to be a significant issue in your brief and is one that doesn't rely on interest of justice jurisdiction. So maybe we could
yes,
talk
it's
about
preserved issue. There are 2 jurors. That's where I was going to go to next. The 2 jurors, Ms. Boyd and Mr. Brandt here, should have been excused for cause. Ms. Boyd admitted that she, quote, may not be able to give her best attention to the case, and as the case got closer to a scheduled trip that she had. At a minimum, the court should have inquired further, and she should have been removed for cause. This falls squarely within this court's case law in Williams and Cephas with 2 jurors who had scheduling conflicts where they said they can't pay attention to the case, and that's exactly what Ms. Boyd said here. And the court's reasons for the denial aren't supported by the record. The court says she never made that statement, but she did. And the court said that the case won't go that far, but the court had previously warned them all that it might go that far, and that's why she raised it at all as a concern.
Well, she was concerned about the date of April 18th, where she had a prearranged trip, she told the court, right?
The may not be able to give her best attention was to the 16th and 17th, which is what the court warned that the case might go until.
That it might go to the 17th, right? That's what the court had said. But in fact, it didn't go anywhere near that far, did it?
It went until Friday because of a conflict that the defense counsel ended up waiving, but it did go until that Friday, which was still longer than the court said when it dismissed the defense counsel's concern about this issue. And defense counsel's question, again, was about the 16th and 17th, which were 2 dates that the court, said this trial might go until.
Right, because they weren't going to serve on Fridays, and then they did.
And then they did, yes. And so it would have gone into the 16th, which is when this juror had this concern. And the issue here was her inability to focus because of that trip, which is very clearly the same case with the jurors in Williams and Cephas. And then Mr. Brandt is another juror as well, who should have been excused for cause, or at the minimum, a further inquiry should have been conducted with him. He used "I think," and I know "I think" is not an equivocal statement automatically, but in this context, the court had repeatedly warned every juror, stop using "I think," stop using "I'll try." These are equivocal statements. You cannot say that. Every other juror that used that phrase, the court inquired further from. The court did not with Mr. Brandt. And Mr. Brandt here has criminal experience. He's a lawyer. He understood what he was doing when he used that phrase, and so that's another basis for the court to reverse.
Well, let's assume that the court erred in denying the for-cause challenges to one or both of those jurors. Would those errors be subject to harmless error analysis?
No, because the harm here is that the defense counsel didn't have the peremptory strike to then use to strike another juror at the jury selection stage. So the court needs to reverse if there is error with one of those, as we've said it is. And then just to touch on any harmless error issue, this case is an incredibly close case that we have argued in point one of our brief was not legally sufficient as to Mr. Bowman's identity. The court can review itself, the videos and the photographs, but there's no complaining witness that identifies him, and it's only reliant on these police officer identifications who had no experience with Mr. Bowman and are making the same judgment that this court would be making based off of that. And just very quickly, Mr. Bowman's sentence here is almost 2 decades in prison to life, more than the minimum, which is already a harsh sentence of 16 to life, was not required under these circumstances. Mr. Bowman is someone who has an incredibly tragic personal history. He was 14 years old when he saw the death of his 9-month-old child. He has substance abuse issues. Mental health has been untreated for years, and he's cycled in and out of this system, but he has made rehabilitative efforts to get his GED, to show vocational programming, and anything beyond a 16 to life sentence is incredibly harsh here for him. And this court has reduced in very similar circumstances with a sentence of 18 and 20 years to life as well. If there are no further questions, I'll...
Questions, colleagues? Thank you. We'll hear from you on rebuttal.
May it please the court, my name is Alice Wiseman. I'm appearing on behalf of the people. Your Honors, with respect to the cause challenges, the trial court acted properly in denying each of those challenges. First of all, with respect to Ms. Boyd, the judge knew in advance, and it turned out to be true, that this was going to be a quick trial. That's what he told the jurors, that he expected the case would finish by the end of the following week, which would be the 12th or the 13th, and that at most it would go into the Monday or Tuesday of the next week, the 16th or 17th. At that point, Boyd mentioned that she had a flight scheduled on the 18th, but she said she didn't think it was a problem, she was just mentioning it. So from her point of view, understanding what the judge was telling her, she didn't think there would be a problem. Obviously, the defense attorney in his questioning tried very hard to pull out of her that as it got closer to the 18th, we got to the 16th and the 17th, would she have trouble concentrating, and she agreed she would. However, the judge recognized, and as it turned out quite correctly, that this trial was not going to get that far. I believe the testimony was completed on the 11th, the jury was charged on the 12th, they reached a verdict on the 13th. I believe on the morning of the 13th, that's 5 days before the 18th. There was no legitimate danger, as the judge recognized, that this case was going to get to the point where it would be the 16th or the 17th, and it looked like the trial was continuing. So in that sense, the judge was proper to say that this potential conflict does not render her incapable of likely not to be able to reach a verdict based on the evidence at trial.
So your understanding was, based upon the way the record developed, that the juror was indicating that if the case got close to the date she was leaving, that she would have trouble focusing at that future time? I mean, that's the question.
Yeah, I mean, that's what she was saying. I don't think she thought of it on her own, but when the defense attorney asked her, well, is this getting closer and closer? And I'm sure that was true. But the judge looked at the case and said, we're not going to get to that point. And they didn't get anywhere near that point. If
So,
she-
but the point is that at the time of the questioning, the judge didn't know that, right? And he didn't know, that at the time of the questioning, they weren't going to go on Friday, correct? And it would have, if someone hadn't waived the conflicts, it would have gone to the 16th, right?
It could have gone to the
And at the time the judge was questioning the witness, the judge didn't know that the conflict was going to be waived, correct?
That's correct, Your Honor.
So it could absolutely have gone into a period of time that this potential juror, this prospective juror said she wouldn't be able to concentrate. And the judge couldn't have known. I mean, in hindsight, we know now, but at that time, he didn't know that the conflict was going to be waived and trial was going to be held on the Friday, right?
That's correct, Judge, but
So why not ask the jurors some more questions?
Well, the defense, as I say, this wasn't something the juror came up with, that this was a problem.
I know, the juror never spontaneously says, or at least my experience as a trial judge, was very few jurors spontaneously say, I'm never going to be fair. It's the lawyer's job to pull that out of them. That's exactly what they're supposed to be doing, right?
Yes, Judge, but...
So, okay, so the lawyer pulls out of this witness. If it gets close to those 2 days, I'm not going to be able to concentrate. And at the time of the questioning, there was a question whether or not the trial was going to go into those 2 days. So then the next question is, why didn't the judge allow further questioning?
Well, nobody requested further questioning at that point.
So what was proper about the judge not allowing it?
I don't believe, Your Honor, that anyone did request further questioning of
Well, I think the defense attorney did ask for the questioning of that witness. No?
That's not my understanding, Judge, but obviously, you'll be able to look at the record. I think, there always has to be a point. If the juror had a trip that was scheduled for the 20th, or there's some day at which the judge can make a judgment how long this case will take. In this case, I believe the judge was very confident that the very outside of this would be the 16th or the 17th, which itself would not interfere with her trip. And if the jury had, as they did, and as they were reasonably expected to do, started deliberating on the Thursday, even if deliberations continued, the deliberations in a case this brief were not going to continue that long. So I think the judge...
I think it's always a dicey call to figure out how long trials are going to take at the beginning. I mean, we've all been confronted with it, and you like to control expectations, but some of it winds up being uncontrollable.
I think that's true, Judge, and I think there were actually delays that happened in this case that were still built in, because this really is... and as they knew going in, a very brief case. We had basically, the people had 2 days of testimony.
So you think, just to shortcut that when the judge said, this may go to the 16th or the 17th, that he was trying to control some expectations just in case.
Right. That was really the outside and beyond what he expected they could reasonably be. And he was quite right that didn't get anywhere near that. With respect to Mr. Brandt, I don't think that what he said, which really had to do with his sister personally, even suggested a serious doubt about his impartiality. And even if it did, what he said, he repeatedly said, I think I can put that aside, I can be fair and impartial. The defense attorney below himself recognized, said, yeah, I know he said he could be fair and impartial, and the judge characterized that as being unequivocal. The defense didn't dispute that. We all know you can say, I think I can, in a way that's equivocal or in a way that's unequivocal. Obviously, the parties who were present understood it to be unequivocal. So I think there's no issue. And again, he never said anything that suggested that, other than perhaps his sister, who was not prosecuting the case, that he had strong feelings about prosecutors. If there are any questions from the court on any other issues? Okay, thank you. We'll rest on our brief.
Thank you. Okay, rebuttal.
Counsel did seek to inquire further. That's on page 289 of the transcript with Ms. Boyd, and the court denied that request. And just, again, the court itself later on, as it gets farther into the case, it remarks, I'm quoting, there's no best case scenario in this case. They had a number of scheduling issues arise that ends up with an alternate juror being dismissed. And I know that respondent points to that juror as someone who also had a conflict with a trip who made it onto this jury, but that was after the fact of Boyd, this challenge not going through. It's an alternate juror, and that person never made the statement that Ms. Boyd did, that she might not be able to give the case the best attention had it gotten closer to the 16th and 17th, which again were dates that the court itself gave to the jury to be worried about. And so for that reason, this court needs to reverse this for-cause challenge should have been granted. At the minimum, there should have been a further inquiry into that juror. Thank you.
Thank you. Thank you both. Next case is Stern versus Sullum. You may proceed.
Thank you. Good afternoon, Your Honors. May it please the court, Stephanie Goldstein for the appellant. It was error for the lower court to have ordered the 1996 infant compromise order to be amended to require the annuities to name the Stern S&T as a remainder beneficiary upon Tara Stern's death. It was error for the lower court to require this amendment in accordance with Sinango. Sinango had no legal analysis to require this to be done. It was error for the lower court to disregard the application of latches. This is an unusual situation to apply latches to a government agency. There was lengthy delay, and there was prejudice to Tara and to Stern, her father and trustee of the Stern S&T Trust. It was also error for the lower court to have found that collateral estoppel and res judicata do not apply. The infant compromise order of 1996 did not need to be
Can you explain the prejudice, though? I mean, it's an unfortunate situation, but Tara Allison Stern received Medicaid for her, when
yes,
her
since
funds
2012.
expired, right?
That's correct,
And it
Your
was
Honor.
over
Yes.
$2 million worth of funds that she received. So where's the prejudice? I'm trying to, when you said there was prejudice to the plaintiffs here, can you explain that a little bit?
Sure, Judge. In the interest of protecting the public interest and preserving a public right, there have been multiple bites of the apple here. The state was on notice vis-a-vis New York City and New York State since 1995. It wasn't until 2019.
What's the prejudice to the plaintiff? What is the father going to lose? I mean, how is he prejudiced by this?
He had to amend an infant compromise order. He had to engage counsel to respond to the motion to compel, to respond to the motion to amend the infant compromise order. A trustee must now stand at the ready to amend a trust or an infant compromise order when the state should be on top of things.
Is that the only prejudice you're claiming?
I'm sorry, the only prejudice?
Yeah.
I mean,
The prejudice is that he actually has to do it?
It sets a very dangerous precedent.
In what way?
The Deficit Reduction Act was the only statutory authority that requires annuities to name a trust, or excuse me, the state as a remainder beneficiary. So now the prejudice is it wasn't required to be done in 1996. The prejudice is this trust in the infant compromise order must comply with the legislation that was not intended to be retroactively applied.
But there was case law, right? We all agree there's case law that says you have to comply, you have to do this anyway.
Are you referring to Sinango?
Yeah.
Sinango had no legal analysis
Okay,
regarding...
but regardless of whether or not you agree that it was the most articulate decision, that common law decision, says the same thing as the statute. Correct?
The statute doesn't say anything about annuities.
I'm just saying that it is a similar, it's a common law ruling that is similar to the statute.
This court, right, this court has no obligation to adopt Sinango.
But it wasn't like there was nothing out there. There is a second department decision at the time saying this is what you have to do.
That's correct, Your Honor. This court is not obliged to adopt that provision.
Okay.
Isn't this
To preclude us
wholly
from adopting it either.
I'm sorry, Your Honor.
There was nothing precluding us from adopting it either.
No, but there is no legal.
It seems to have some sound public policy behind it. It's not like the intended beneficiary of the Supplemental Needs Trust is not getting her needs met, which is what the trust was, and the infant compromise order was designed to do. It wasn't meant to benefit the surviving relatives of the incapacitated child, was it?
Right, but Your Honor, the whole point is this was not required in 1996, and now 20 years later, it's a requirement. That doesn't make any sense. You're asking for an infant compromise order to prospectively be compliant with subsequent legislation. It doesn't make sense. It doesn't.
Well, no, the court didn't rely, unless I read the wrong case, it didn't rely on the Deficit Reduction Act. I mean, the 2006 law. It went and relied on the case law.
That's correct, Your Honor. It does rely on the case law.
Right, so
the Deficit Reduction Act is the only statutory authority that qualifies for the treatment of annuities as such as Sinango required.
Right, but
the
it's
only
not. But it's
legislation.
but it's commensurate with the case law. It's not like it's overruling the case law. It's just put into legislation what the case law already says. So it's like it's on the same page. It's different if the Deficit Reduction Act was a total abrogation of that case. Then I would say, okay, then you got a good argument. But it didn't.
Right, may I just respond to that?
You may.
Thank you. Very briefly, Sinango required something that wasn't required. And now the Infant Compromise Order of 1996 is being required to be in compliant with essentially the Deficit Reduction Act. Thank you, Your Honors.
Thank you. You can proceed.
May it please the court, Zach Shapiro for the Department of Social Services. I'd like to start off by pointing out the opposing counsel's use of the word error, which he used several times. We submit that the question here was rather a question of the Supreme Court's discretion to amend the order, and Supreme Court providently exercised that discretion in amending the order. Indeed, at page 4 of their reply brief, they concede that at the time there was statutory authority to require the annuities to name the state as the S&T as the beneficiary. And certainly it's not an abuse of discretion to require that same result now. In fact, it's consistent with what the Second Department correctly recognized in Sinango. That was, as Your Honor's questioning pointed out, that was before the Deficit Reduction Act. It was perfectly consistent with what Congress was doing in the Deficit Reduction Act, which of course, we're talking about a 50-state program here. Just because New York reached the right result in Sinango, that didn't preclude Congress from making clear that that was the right result for the rest of the country as well.
But isn't there a fundamental principle here we're supposed to give effect to that has existed long before this infant's compromise order was executed, and that is that Medicaid is the payer of last resort?
That's absolutely right. That Your Honors should give effect when interpreting the statute to that clear public policy that's clear from several aspects of the statutes themselves and from the Court of Appeals precedent, that Medicaid is only designed to serve as a payer of last resort because it's designed to cover the medical costs of low-income individuals who would not otherwise be able to do it. The S&T
and your recovery under those scenarios is to benefit the public. I mean, all those future individuals who seek you out as the payer of last resort. I mean, you got to get funding back somehow if you can, right? I mean, you don't have a bottomless pit in terms of funding, right? I mean, if you can get it back, and then you can pay it forward to someone else.
That's absolutely right, Your Honor. And to highlight the point, what we're talking about here, we're not arguing anything that would harm Stern herself. She clearly gets the benefit of the annuities during her lifetime. What we're talking about here is, can Medicaid recover the more than $2 million now that it has paid from anything that's remaining from the annuities?
It's two annuities.
I'm sorry?
I believe there's 2 annuities,
There are
correct?
3 annuities.
There's 3, okay.
Can Medicaid recover that amount so that it can go and benefit other low-income individuals, or does that money go to Stern's heirs? It was never anyone's intent that Stern's heirs should benefit from the settlement. The settlement was designed to benefit Stern herself. Indeed, if you look at pages 305 to 306 of the record, you'll see that plaintiffs themselves argued for a provision in the S&T that would have made clear that the purpose of the principle is to benefit Stern and should not be saved for any remainder people.
Well, isn't that because if that language isn't there, then it doesn't qualify under the EPTL as an S&T?
That's right, Your Honor. The state objected to that language because the state has a remainder interest in that amount, and so it has an interest in making sure that funds are inappropriately depleted. But that highlights that we're not trying to do anything that plaintiffs themselves wouldn't have accepted at the time. The settlement was designed to benefit Stern. The S&T exception is designed to benefit Stern. The S&T itself was designed to benefit Stern, and nothing we're doing will harm her in any way. In fact, what we're arguing for is to make sure that she continues to be eligible for Medicaid by correcting what Supreme Court correctly did was to correct the settlement order to make sure that her eligibility would not be at risk. I'd be happy to answer any other questions Your Honors have. If there are none, we ask the court to affirm. Thank you.
Thank you. Rebuttal?
Thank you, Your Honors. Very briefly, we're not arguing that the state should not be the payer of last resort. New York State was adequately involved and acted accordingly to protect the state's right to be reimbursed. And counsel did mention that the state objected to certain language, and the court agreed with it. But where was New York City? They had their opportunity, and now, 20 years later, they find fault. I must mention that in their briefs, they do mention that they are the experts. Weren't they experts in 1996? New York State was also an expert in 1996 and found no issue with the annuities and the payout structure at her death. Thank you very much, Your Honors.
Thank you. Thank you both. Trigon?
Good afternoon, Your Honors. James Schwartz for Plaintiff Appellant Respondent Trigon. Justice Gish, when I answered the calendar 2 hours ago, you asked me to keep my time down as much as possible. I'm going to try very hard to do that.
Thank you. You have the full 6 minutes, though, although we're spending 15 seconds with this discussion.
I understand that. There are 2 issues facing the court. One, whether an assignor of a lease who's in privity with a landlord who then assigns its lease to an assignee is liable for rent defaults that occur by the assignee. And unless the law is absolutely clear that unless that assignor obtains a release, it is liable. What does the defendant in this case say? They have nothing in the contracts themselves. Rather, they resort to extra contractual claims, such as that the landlord accepted rent from the assignee. As a matter of law, that's no defense. This court is so held in 185 versus Ryan and Mandel versus Fisher. They say, we call the assignee the tenant. Well, the assignment of the lease breaks privity of estate, but not privity of contract. The assignee was indeed the tenant.
But there was another, you asked and got an estoppel certificate, so what significance did that have?
The assignee was the tenant under the lease because it was in both privity of estate and privity of contract. 1652 assumed the obligations under the lease. Therefore, it was the tenant. And so we had the absolute right to ask for a certificate of estoppel from it. SDKD, which had assigned was no longer the tenant. It only had contractual liability. And that's this court's holding in the Howard Stores versus Robeson Rayon case. In addition to that, they say that we are stopped to claim that there's liability by SDKD because for so many years we dealt with 1652. Well, that's the nature of a contractual liability. The relationship with 1652 was working out, but nevertheless, when it foundered, we were entitled to turn to SDKD. We orchestrated the manner in which this took place. At the time that the assignment took place, there was 10 months left on the lease. What did SDKD do? It entered into a 10-year lease for $5 million in lease liability. The 10 months of rent due under the lease pre-extension was only $220,000. They could have clicked their heels and walked away. In short, there's nothing here that prevents SDKD from being liable as a matter of law. Now, let's talk about who was responsible. Who was the assignor? SDKD had been volitionally dissolved in December 2013. Yet almost 2 years later, its principal, Mr. Chand, signed a lease on behalf of SDKD in which he represented in the signature block that SDKD was a New York corporation.
But a question was raised, or wasn't it, about whether SDKD was wrapping up business. In other words, it was still involved in wind-up activities.
Yes, Your Honor.
Notwithstanding that, it was 2 years after its dissolution.
As a matter of law, the winding up here would be having the lease run out. But
Wait a minute. Say that again? What law says that you have to have the lease run out?
there is no law. No law says that, but logic tells you that, Your Honor.
Why can't, as a part of my winding up of my business, I sign a lease modification assigning everything I've got to someone else for purposes of taxes and everything else? I'm not saying as a matter of law that that's what happened, but I'm saying that that at least is a plausible way to wind up your business.
Because, Your Honor, the lease was about to run out. There was
I don't know why that would make a difference as a matter of law. It may be as a matter of fact, but not as a matter of law.
Well, the assumption here was that Mr. Chan said that he thought that that the transaction here, forgave him from any obligations he had under his guarantee and under the lease. And there's absolutely nothing that says that. Now,
well, wait, but there is. One, you accepted the new tenant's much bigger security, the letter of credit, right?
Right.
Two, you issue an estoppel certificate, right? It doesn't say anything about the defendant remaining liable. And three, you're accepting rent, which I agree with you as a matter of law is not enough. But all of that together might raise an issue of fact.
May I, Your Honor?
You may.
Assuming that it raises an issue of fact, Mr. Chand is still liable because if it was winding up, this court's case involving the Broadway musical South Pacific, Rogers versus Logan, says that where it would be futile to sue the corporation, you can go directly after the directors for their withdrawals. And here, the defendant itself says that it has done no substantive business since its dissolution in 2013. So therefore, on that fallback basis, there's personal liability for Mr. Chand, whether it was winding up or not winding up. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. May it please the Court, Eric Porter for Respondent Appellants, Mr. Chand and SDKD. Your Honor, Trigon's position here would require us to blind ourselves to the facts that are clearly established in the record, that everyone knew exactly what was going on here. In 2012, SDKD sold the entirety of its business, this restaurant at the property, its reason for existing, to 1652. In 2013, it dissolved. Everyone knew that SDKD was done, that it was no longer doing business. It approaches Trigon in 2015 and says, hey, can we end this lease? Can you create a new lease with the actual new tenant, 1652, that's been in place paying rent since 2012? Trigon says, we would much prefer to save the time to negotiate a new lease. Let's just extend your lease and simultaneously assign it over to 1652. We know that everyone knew that was the situation because the lease written by Trigon reflects all these things. The lease has a series of restrictions on assignments, all of which are expressly carved out in the case of an assignment to 1652. As Justice Scarpula pointed out, the lease increases the security deposit by 600%. There's no rational reason to do that unless you've got a new tenant coming in and you don't necessarily have the same confidence in their financial situation. The email correspondence that we've produced in the record, at the time that these documents were...
Let me ask you this, counsel. As if everybody knew it as a matter of law, why not just get a release? Right? It's not clear to me that everyone knew it as a matter of law. Because if they did, the landlord would have said, I release you from any obligation under this lease. Isn't that the clearest and cleanest way to do that?
Your Honor, with the benefit of hindsight, yes, but in the moment
So what you say is the story is not what the landlord says is the story. And so I think if you're asking us on the basis of the documents to decide what the story is, I don't think we can do that as a matter of law either way.
Well, Your Honor, even if there's a factual dispute over what was known at the time, we believe the documents are still strong enough to merit summary judgment on both of those 2 points that Mr. Schwartz pointed out. And I'll take them one at a time.
So again, without an actual release, which is the normal way to do it,
yes.
What do you think entitles you to summary judgment?
Yes, Your Honor. And well, I'll start with the point that the release goes to, which is whether or not SDKD remains liable. And then if I may just talk about Mr. Chand personally. SDKD, even without an express release, and again, we don't concede that it's not there, but this court's determination in 185 Madison was that, yes, it's not enough to just passively consent to the assignment to relieve the assignor. Yes, it's not enough to just passively accept rent to release the assignor. You need something more. You need something showing that the landlord accepted the assignee as the new tenant and that there was either an express or an implied release, right? So it's not just that you need something in black and white. The facts can establish an implied release. And here, those facts we submit do that.
As a matter of law, Madison didn't say that you could, it can give you a chance to go to the jury, right?
Yes, Your Honor, but well, it doesn't say one way or another whether it can be established that you need to go to the jury or not.
I guess the point is that an implied release is sort of factually driven, and it doesn't sound like it's really summary judgment friendly, as opposed to a written release, which is way summary judgment friendly.
I understand that, Your Honor, but again, we do have the documentation here. As Justice Scarpula pointed out, this estoppel letter, Trigon drafted it, and it specifically identifies the lease as now between Trigon as landlord and 1652 as tenant, as successor in interest to the original tenant from 30 years ago, without even mentioning SDKD.
But it doesn't, on the other hand, say what many estoppel certificates do say, is that, and I no longer have any claim under against the old tenant. I mean, lots of estoppel certificates say that, this one doesn't.
That's fair, Your Honor.
Right?
It does not say that. It does not say that.
Again, my question to you is, on that, you want us to issue a summary judgment determination?
Well, it's certainly not enough for the same reason to enter summary judgment in their favor, Your Honor. But we do think those facts are sufficient to demonstrate the existence of an implied release. That aside, though, Your Honor, this question of personal liability for Chan is certainly able to be determined as a matter of law. This was clearly winding up. This company, SDKD, had been doing no business for years, had sold the entirety of the restaurant, had dissolved as a matter of public record in 2013. And this was the last lingering vestige of their business, the name of the company on this lease. This was the way that they determined that Trigon dictated that they would transition the lease, their last asset, to the actual tenant, 1652. The business corporation law gives wide latitude, broad latitude to dissolved corporations to act towards the liquidation of their business, to act towards the wrapping up of their business. If this wasn't winding up, what was it? The SDKD didn't have access to the property anymore, didn't own the restaurant. They weren't doing any substantive business. This was the last thing they did to wrap up the last lingering vestige of what they had, and the mechanism that they employed was the mechanism that Trigon dictated that they employ. So we think there's more than enough here to dismiss a personal claim against Chan, Your Honor. As to this liability under Rogers, Rogers, by its very language, is limited to post-dissolution distributions. This company had no income for over a year before dissolution even occurred. So we don't think there's any, and they haven't even alleged in their initial complaint this basis of recovery. They haven't alleged that there were any distributions. There's just no basis for recovering here on that theory, and we think that can be decided as a matter of law.
Thank you.
Thank you.
All right, rebuttal.
Your Honor, the Rogers issue is emphatically not summary judgment. We haven't had discovery on it. We have no idea what kind of distributions that Mr. Chan took. And indeed, in the retirement fund case cited in my brief, it's not limited to post-dissolution distributions. In that case, the federal district court here in the Southern District, applying New York law, allowed recovery of for a reasonable time, 2 years before. But what that reasonable time is, that may indeed be a question of fact, but it's not limited to the moment that the corporation dissolves, because if that were the case, it opens itself up to all kinds of mischief. I'll take out $10 million 2 days before before we file the certificate in Albany, and then you file a certificate in Albany, and there's nothing left in the corporation, and it just doesn't work that way. It opens itself up to mischief. As for summary judgment on any basis to Chand and to Mr. Chand and to SDKD here, the documents favor my client. The issues that my learned adversary raises concern what his thoughts were about the transaction, what someone said to somebody else. That is inherently, on that side of the case, that is inherently a question of fact. Mine not, his yes. Thank you, Your Honors.
Thank you. Right. Go ahead, you have rebuttal.
Thank you, Your Honors. The language of Rogers makes clear that we're talking about post-dissolution. That's the key quote. The money quote from Rogers is, after dissolution, distributions made to shareholders are to be held in trust. The only case that I have located that actually addresses that issue is a case called Spectra, and the court there reached the exact same determination. The decision that my learned adversary cites does not, in fact, address that issue. It doesn't appear to have been raised whether or not we were dealing with pre- or post-dissolution. And this idea that a post-dissolution cutoff point, or a dissolution cutoff point, I should say, for a Rogers-type recovery would set off all sorts of mischief. We already have laws that prevent that. If I was to take $1 million out of a business the day before I dissolved it, I'd be subject to a fraudulent transfer. So you don't need to change the law on Rogers that stems from the exact language of Rogers in order to prevent the parade of horribles that Trigon argues for. And to be clear, there's not even a whiff of an allegation that anything like that happened here. Again, this company sold its last remaining business off in 2012, dissolved a year later. This is not a situation where you've got the heirs of Rogers and Hammerstein making money off of South Pacific and being subject to having to pay some of that out to existing creditors. This is a restaurant that closed, stopped doing business, the guy's out. and 3 years later, he wraps it up, winds up his business by assigning it to the actual new tenant and does it with the mechanism that Trigon itself devised. So with that, Your Honor, I would yield the rest of my time unless there are any questions. Thank you.
Thank you. Thank you both. Thank you for wading through our whole calendar this afternoon.
Alrighty then.